2022. This is a continuation of the Anderson Early et al. Case, and I notice everybody is here. Mr. Bourgeois, I don't see him here, but I know he is comes in Zoom. His client is not here, but other than him, everybody else is here. So thank you. So seems every time I come in the morning, there's always a little packet of information waiting for me. So some early morning reading. You know, why don't we just on the very first day there was a motion on concerning the records, you know, coming in from the AG's office, and it was subject to a protective order. And we had kind of addressed it, and then as the days went by, we addressed it kind of, thank you, like a little further, saying, well, if there's something in there that should be redacted, please redact it prior to, you know, us getting it in the record. So I think the time is, you know, and I think I asked the parties to do that. I don't know whether the parties have met and done that, but I would ask you, because there have been requests from the press, and understandably and rightfully so, to see those exhibits. So, you know, they're certainly entitled to see it. I want to expedite them seeing that. But I just want to make sure that nothing is revealed that should not be revealed. So have the parties had an opportunity to go over the statements and redact what you believe should be redacted?
Yes.
Okay, you had to think for a second. So.
Well, no, we produced the redacted AG transcripts that redacted the private information that you said we would
Right.
redact, so.
Okay, well, if
I may move one in today that I think is AG. It might be Ethics Commission.
I think it's ethics.
I think it's ethics, and I think it was sworn.
And I think it's redacted.
Yeah, I think redacted. I know I have redacted. I'm not sure what's up there.
well, I'm just asking the parties to just make sure before, you know, because it was a motion, and I'm going to, you know, allow the motion to release it, you know, release my protective order, basically. But I just want to make sure that everybody has had an adequate opportunity to review what's in those somewhat voluminous records, and make sure you take out not only, you know, personal information, cell phone numbers, email addresses, but something else that, in your view, should not be there. So I'm just going to ask you to do it, and if you're satisfied, I'm satisfied.
So we are satisfied that we comply with your protective order.
Okay.
That you issued on those records.
Okay.
That sort of spelled out what the confidential information was that we were agreed to take out.
Okay, well, you know, that's, okay, if you're, I appreciate that, and I just want to make sure the respondents have.
I will look again. My objection at the time was commission's rules don't go far enough, and I don't think we ever resolved that matter. I don't think any of the redactions go as far as I asked for.
Okay, so I'll just wait for sometime later today, perhaps. Mr. Burke, you have a position on this? Have you had an opportunity?
Judge, I think you have been pretty open-ended in terms of allowing evidence, so I don't think there's anything that's needs to be further redacted, so.
Okay, Mr. Viscardi, if you.
To my knowledge, and the documents in front of me with respect to AG transcripts that I've been referencing the whole time actually have redactions, and I'm just assuming that the same exhibits that are.
Just make sure you check with Ms. Duca during the break. Ms. Bourgeois, do you want to be heard on this?
No, sir. I joined the discussion late. I'll confer with
I'm just having some trouble hearing you. Hold on one second, please. Okay, Mr. Bourgeois.
What I said was I joined the discussion late to get into the meeting, but I'll confer with the other respondents' counsel.
Okay, and then, so once you're ready to join your sister counsel and giving me the thumbs up, I'll take the appropriate action. There's some other motions before me. Frankly, I'd like to resolve that a little later because I'd like to get into this matter. I'm hoping to finish this tomorrow and you know, move along as expeditiously as possible. So with that in mind, you know, why don't we get going now, and then I'll address, you know, Attorney Sullivan's motion and the petitioner's motion for closing argument before the full commission and the opposition to there too, okay? You don't need a decision now. Well, I'll give you that. We can discuss that later today. Is that okay? Or do you want me to resolve it now?
No, we can definitely discuss it on the record today.
Okay,
Thank you.
okay, so I'll do it. Okay, so, Mr. Rusconi, I understand you've rested. You've called your,
I've called my witnesses, yes.
yeah, so you have no witnesses further to call,
I
right?
do not.
Okay, and Mr. Bourgeois, I believe, is in the same camp as you. He put on his evidence last Wednesday, I believe. So,
Yes, sir.
Is that correct? Okay, thank you. So, Mr. Burke, we turn to you, sir.
Thank you. Respondent call Susan Anderson.
Good morning to you, ma'am.
Good
Can
morning.
you raise your right hand? Do you swear to tell the truth, the whole truth, so help you God?
I do.
Okay, thank you very much.
Good morning. Would you state your name for the record, please, and spell your last name?
Good morning, my name is Susan Anderson, Anderson.
And prior to your retirement, would you tell the commission where it was that you worked?
I came out of the academy in 1983.
Can you hear her? Yeah, I think because I can hear you,
Okay.
so if you would direct your comments to
Um,
Attorney Burke, then the
Okay.
report will be a little easier for her.
I graduated the academy in 1983. And I was stationed out in Brookfield, which is part of Troop C, for several years. And then I was at the Holden headquarters for several years. I worked in the old Worcester CPAC for 3 years,
Nobody knows what CPAC means.
not anymore.
They don't have them anymore,
It's
right?
the old, it's the new, they now call it the State Police Detective Bureau.
Okay.
I was in there for 3 years doing child abuse and rape cases. Then I was transferred, I requested transfer out of there back to Holden. And took promotion exams over the years. I did 12 years as a sergeant, 9 years as a lieutenant, 3 years as a captain, and 3 years as a major.
What's your educational background?
I have a bachelor's degree in criminal justice from Westfield State University.
Okay. And back when you first came out in 1983, how many state police officers were there?
Total? Maybe 600 or 700.
Okay. And approximately how many women?
Maybe 25,
About 600.
I believe so.
And during the time period that you were there, so 1983 till 2018,
Correct.
so 35 years?
Yes, sir.
Pretty quick math, right?
Mhm.
And you became a major. What's the next highest rank above that?
Be a lieutenant colonel.
Okay. And how many women have ever risen to the rank of major in the state police?
When I was on, maybe 5 or 6,
In the history of state police?
as far as I can recall, yes.
Sure. And you have to take promotional exams for sergeant, lieutenant, captain,
Correct.
and is that based upon your overall academic rating and score?
Yes.
Are there other components to that?
They used to have oral interview, or like an oral board, they called it.
Okay. And as a member of, when I use the phrase paramilitary organization, what does that mean to you?
That the state police is based upon a military model. And you have someone who's in command and everything flows down.
Okay. And is there an organizational chart within the state police?
Yes.
Broken into different divisions, field? And field is what?
Field would be all the barracks, all the troopers that are patrolling the highways.
Okay. And when we say troops, you and I know what that means. How many troops are there in the state of Massachusetts?
A, B, C, D, E, F, G, H, Aye,
Okay, and so,
I believe.
all right. In terms of C Troop, where is that geographically?
Central Mass.
Okay,
There's 9 barracks in C Troop.
all right, so there's 9 separate stations or barracks within that area.
Yes.
Approximately how many towns?
205, 207.
And when you rose to the rank of major, are you in charge of the immediate day-to-day activities of all of those individuals who are subordinate to you?
Yes.
That's your responsibility.
Yes.
And you've been a captain before that?
Yes.
Where were you a captain?
At Holden.
Okay, and is that sort of like the second in command in terms of
Yes.
the C Troop? All right, and when you say that you did this for 3 years, can you tell me like some of your day-to-day activities were as the troop commander going to the last 3 years as a major?
Well, it was
What do
different.
you do every day?
It was different every day, but I would come in and there would always be a pile of reports or journals or something on my desk that I may have to look at or respond to a lieutenant about or a sergeant about. I would look at activity to make sure that the troopers were doing what they were supposed to be doing. I would review the daily activity reports. Might have a meeting with a local department or have to call a local department about something that went on.
You do a lot of problem solving,
Yes,
and do you have day-to-day interaction with members of the various barracks that you're supervising?
either via telephone or in person, yes,
You consider that to be a lot of responsibility?
yes,
You ever get vacations?
yes,
Going back to, and of course, you know what we're talking about, obviously, October 16th, 17th, 18th, and 19th.
yes.
That's 4.5 years ago. And roughly, were you on vacation on or about October 16th, 2017?
I was.
And how long were you on vacation?
Possibly a week, I don't recall.
So when this arrest of Miss Bebo occurs on October 16th, 2017, at 7:35 p.m., where are you?
On vacation.
Okay. Do you have any role in her bail setting or anything that took place there?
No.
When did you, at some point in time, did you get a text or an email from anybody within your chain of command?
I received a text message from my administrative captain, Captain Johnson,
Okay, what's his first name or her first name?
Robert.
An experienced officer?
Yes,
Do you remember what that content was of the text or email you got? Which was it?
it was a text message
Okay.
to my personal phone,
All right,
I believe, and it basically said, C6 arrested judge's daughter,
Okay.
something to that effect.
all right. So C6, just so we're clear, what C6 is
The
about?
Holden substation,
Say anything about the arresting officer or anything other than just that?
just that comment.
Okay. All right, you've heard testimony that there's a need to know of significant events that happen within your jurisdiction or your area of control.
Yes, sir, situation awareness messages.
Okay, SAMs.
Yes,
All right, and did you know who the judge was?
No.
Did you ever have any prior, you know who it is now, obviously.
yes,
And when you got that text, do you remember what time of day or morning or evening it was?
I don't recall.
The text didn't contain the name of the person, did it?
No.
Okay. Did you take any steps whatsoever to do anything with regards to the judge or that arrest or anything conducted or concerned with that when you got that text?
No.
Have any interest other than just storing it for informational purposes?
Exactly, I didn't even respond.
Did you contact anybody to say, hey, you better do something about this?
No, sir, I didn't respond and I just put my phone away.
Okay. on vacation.
Yes,
So that's the 17th, right?
okay.
Well,
Sorry, I was
Let
on
me-
vacation.
Let me suggest to
Yes.
you that the record would reflect that there was a text
Text
sent to you
message on the
on the
17th.
17th.
Okay,
During that day, the 17th, did you take any steps to do anything connected with that case?
No.
Did you care?
no,
The 18th, where are you? Or what are you doing?
I don't recall whether I was back or still on vacation.
Okay? Well, either way, we'll take it both ways. For purposes of testimony here today, assuming you're on vacation, still where you were, did you take any steps on the 18th?
No.
Flip it. Were you, when you assume you came back, is there any indication that you took any steps on the 18th?
No.
Do anything or have any connection, make any inquiry as to who the judge was or what this report looked like?
No.
Okay. Now, for the 19th. Now, again, 4.5 years ago, do you have a perfect memory of everything took place on the
I do not.
April 19th? Okay. Was there something, did you at some point in time make some notes about a conversation that you had?
Yes, sometime that morning.
Okay. Let me back up first. Did you go back to work on the 19th?
I did,
Or were you at work on the 19th?
yes.
What is your normal shift? Do you have a shift? Do you just,
Normally 7 to 3:30, but most mornings I'm in there by 6 and was leaving at 5.
okay. Did you have any interaction with anybody about this case prior to getting a phone call?
Captain Johnson in the morning.
Okay. Tell the commission what happened. This is the guy you said was your executive?
Right, shortly after I arrived up in my office, Captain Johnson came in and said, "You're gonna wanna see this arrest report." And he handed me a copy of the arrest report
Okay. And just so we're clear, the arrest report is the one
of
that's,
the judge's daughter, Ally Beaver.
okay. And did you take a look at that?
I did,
That the first time you saw it?
yes.
Did you go looking for it? Did somebody bring it to your attention?
Captain Johnson brought it to my attention.
Did you read it?
I did,
35 years as a police officer, captain, having responsibility as a sergeant, lieutenant, captain, and major. Did you find anything problematic with that?
I did.
Can you tell us what, if anything, you said or did at the point in time when you actually read it?
I thought a lot of the included quoted statements were unnecessary. They were vulgar, prejudicial against the defendant, and personally felt they did not belong in the report. It was unnecessary to go towards probable cause.
Did you have any other observations of anything was brought to your attention that day?
Regarding the report,
Well, in regarding the case.
the only other thing was I received a phone call about the same time I picked up an impoundment order that had been placed on my desk.
All right. Prior to your return to work on the 19th, had you ever seen that impoundment order?
No.
Can you tell the commission where that impoundment order came from?
It was a copy of a fax that came from Worcester District Court.
Okay, and again, that is 4.5 years ago. What do you recall about the substance of that impoundment order?
It was handwritten by the defendant's, Bebo's attorney, requesting that the report be impounded due to possible pretrial publicity statements to that effect.
Okay. Do you recall by any, with your memory as to who the judge was that issued that?
Only from the hearing. I didn't recall it on my own. I understand it was Judge Locke, but
Okay. Was a fax at that time or using faxes?
yeah, it was a faxed copy that they must have faxed it downstairs to the court officers and someone brought it up to my office.
Okay. So you're getting the police report. Is that the first time you saw that police report?
Yes,
And is that also the first time you learned about the impoundment order?
correct.
That text that you got didn't say anything about an impoundment order, did it?
No.
Okay. So you get those two combinations, those two factors. What's the next thing you recall happening?
I received a phone call from the colonel,
Okay, and when you say the colonel, who are we talking about?
Lieutenant Colonel Daniel Rustine.
And you've been here obviously for all or most of the proceedings.
Yes,
Uh, So Daniel Rustine testified yesterday. That's who you're talking about, right?
yes.
Did you make notes of the content of your conversation with Colonel Rustine?
I did.
Why'd you do that?
Two reasons. First, he asked me to, and second, I always have blank papers on my desk, and while I'm talking on the phone, I'll like scribble notes,
Okay.
just so I don't forget stuff.
Do we know what exhibit this was, the
I think
notes?
it's 12.
Is it 12?
I think it is.
Can I just see that, Lauren, please?
Yes, it is 12.
We want to make sure it's at the bottom of the pile to make it more difficult for you.
Is this it, Mr.?
It is, Judge, yes.
Okay.
Could you take that, please? Judge, do you have a copy of it?
I don't. It's okay, I'll look at it after.
Okay. This is what's been marked as Exhibit 12. You tell us whose handwriting is this?
That would be mine.
I do have a copy now, thanks to Ms. Duca, so thank you.
You all set? All right, let me just ask you, did you write this at or about the time of your conversation with Colonel Rustine?
As he was talking, I was writing it.
It's all in script, isn't it?
Yes,
You see a number that's down in or it's in the lower right-hand quadrant of the
yes.
page. What is that number?
0910,
Okay, what does that stand for?
9:10 a.m.
Okay? And as you said, you're in your office and you got this phone call?
Yes,
And was it on a hard line or on a cell phone?
hardline.
And just go up to, can you explain your notes there and just go in a circular manner if you would? Go up to the upper right-hand corner.
Yes,
You see where you have that partially boxed off?
yes,
Am I reading this correctly? It says, quote, probable cause elements only,
yes,
end quote, right? Did you write that?
I did.
Why'd you write that?
He said it several times. That's also why I have it
He who?
boxed. The lieutenant colonel.
Okay. And what was that in context with?
He had been talking about one statement in particular, but he was talking about statements that were contained in the Bebo arrest report.
Okay,
And he wanted statements that related to probable cause elements only.
all right. And that's why that's boxed in, because it was repeated,
Yes,
all right? Can you go to the left? You see where it says, quote, negative or derogatory comments
Yes.
underlined? Why'd you write that?
he was stating that he did not want any negative or derogatory comments included in the report as they were unnecessary and did not belong there.
Okay, and when you said negative or derogatory comments, by this time, when you're writing this, you've already read that report, haven't you?
Yes,
And you've already learned about the impoundment order, correct?
yes.
Okay. So did you know specifically what the negative or derogatory comments that he was referencing?
Yes,
Do I need to repeat them?
not to me.
Okay. I've asked you to go to the right, but I'm going to have to go down to the left. You see where it says on top of report revised, underlined twice.
Yes,
Did you write that?
I did.
Why'd you write it?
Colonel made several comments that he wanted the word revised written at the top of the report, at the beginning of the gist.
Okay. Was that subsequently done?
I found out, yes, it was.
Okay. So this is at 9:10 in the morning. You hadn't met with the arresting officer yet, had you?
No.
So at 9:10 or about, you're getting instructions from whom to write revised?
Lieutenant Colonel Rustine.
Okay. And see where it says the word report and comment. What is that?
I think I was supposed to write Sevior report, and meaning that Sevior and Conan I was to order them to report to Holden.
Okay,
Even if it was their day off, they were to report to Code 7, which means to report to the headquarters,
okay, so code 7 means what?
to report to the barracks or wherever you're told to report.
Okay. And just go down to the lower left quadrant. Now you see where it says, quote, hand delivered to the ADA and defense attorney, right?
Yes.
Why'd you write that?
That was later, towards the end of my conversation with the colonel. He wanted to make sure that Trooper Sevier hand-delivered the revised report to the ADA. He did not say a name, just the ADA, and to the defense attorney.
Okay. So these revisions that are being made, it's not just going to Joe Early's office, is it?
He never mentioned,
Okay.
he said deliver to the ADA and the defense attorney.
So the ADA gets the defense attorney gets a copy of this as well, right?
Correct.
Is she entitled to that?
Yes.
And does that have any connection to the impoundment order? I'm sorry, the motion that she had filed to impound the original one?
Yes.
What is that connection?
Well, the reason that the judges, let me back up. So the impoundment order stated that the courts allowed it. And in her statement, she said due to the possibility of pretrial publicity due to statements that were included in the arrest report. To the best of my knowledge, that's what was included in the impoundment order.
Okay. And did you in fact ensure that she would get the same thing based upon her motion to impound?
Yes.
So she would have had the original plus the revisions, correct?
Yes.
Okay, now in the center, it says the word immediately, code 7 immediately, right?
Yes.
Right, and then there's Jim Fogel, who's he?
He was the lieutenant of the C6 substation,
All right, and C6 again is what, Holden?
the Holden substation,
Where's your office?
on the second floor of the Holden barrack building.
Okay, now, so if the arresting officer is assigned to C6, which is Holden, the
Yes.
barracks there, you're on the second floor.
Correct.
Do you have any extensive or any interaction with that person?
No.
Any adverse confrontations or any kind of issues with him?
No.
Before this?
No.
Then you wrote, quote, inappropriate commentary, right?
Yes.
Tell us what that means.
To the best of my recollection, it's referring to the EESs that they were to be issued. It was due to the inappropriate commentary within the report.
Okay. You've read this police report, have you not?
Yes.
You go through the first 7 paragraphs, right?
Yes.
You think you've made any OUI arrests in your career?
Yes.
How many?
Over 100.
And you see the last 2 paragraphs, 8 and 9?
I think she
No,
has
I
it
don't
in front of her.
Okay.
I can give her the exhibit if you want.
If you haven't, Judge, that'd be great. Appreciate it.
Exhibit 1, is that what you want?
Yes.
Okay, yeah.
Thank you, sir.
Testing your memory without it. Can you look at are you familiar with the last 2 paragraphs?
Yes.
Is that where these statements are contained?
Objection.
Your objection is?
It's not clear what statements the question's referring to.
Well, I think he said, the statements in question. Do you want him to be more particular?
No, I just thought that he said the statements and I didn't understand. I just want the record to reflect. You're talking about the statements that were later removed from the police report? Thank you.
I think that's what we're discussing.
Did you understand me?
Yes.
These statements in question, Are they contained in the last two paragraphs?
Yes,
Do the first 7 paragraphs, if not the first 2 paragraphs, contain sufficient basis for probable cause for the arrest for an OUI and operating under the influence of narcotic drugs?
yes, they do.
Now, can I just have you go back to your notes? There's a negative EES comment and revised report, right? You have to say yes or no.
Yes.
The record's clear. All right, so why'd you put that?
Just to remind myself that it was gonna be a negative EES and that they were to revise the report.
Okay. You ever been given an EES?
Yes,
Did you consider that to be discipline?
No.
Is it based upon your training and experience discipline?
no, not at all.
Were you sued in federal court as a consequence of the actions you took, alleging that you had violated the arresting officer's constitutional rights as well as imposing discipline upon him?
I was.
We've said this before, but what happened in that case?
It was dismissed by Judge O'Toole.
Okay. And that's after a hearing and after briefs were filed by both sides?
Yes,
You weren't named in any subsequent suit, were you? All right, so after you had gotten your notes, was it clear to you that you were being given an order by Colonel Ristine to take the steps that you subsequently took?
yes, he stated it was a direct order.
Okay. Now, you know the consequences. Well, first of all, did you believe that you were complying with a direct order, a legal and lawful direct order, when he gave you those instructions?
Yes,
Any hesitation in your mind?
No.
All right, so then tell the commission what you did, please.
I contacted the supervisors of Trooper Sevior and Sergeant Conan.
Right.
To relay to them that they were to Code 7 to the Holden headquarters.
That's what you said, you're the Code 7, right?
Yes,
All right. What's
and they
next?
were, the supervisors were to contact me when they made contact with the 2 parties.
Right.
And Lieutenant Fogarty from the Holden barracks was to issue the EESs.
All right. Did you subsequently meet with Trooper Sevier?
I did, Trooper Sevier and his spam representation,
When you say spam, we're talking about the union,
the state police union.
all right? And when you say representative, that's a person who was with them during this meeting with you?
Yes,
All right.
Trooper Gilbert.
And can you just describe for us what your demeanor was in your conversation with Troop? First of all, where did it take place?
In my office on the 2nd floor.
Okay, so he arrives, you're there, were you by yourself with Trooper Sevier and his troop rep?
Yes,
Anybody else?
no,
Your demeanor, can you tell us what your demeanor was like that day? When you met with him?
calm. I didn't feel like I was disciplining him about anything. It was calm. I was relaying a direct order to him. And I was empathetic to him.
You heard me ask him that question on cross, didn't you?
Yes,
Did he agree that you were empathetic?
yes,
Did you yell at him?
not at all.
Okay. And did you explain to him why you were doing this?
I explained that it was a direct order.
Okay.
And that we also had the impoundment order that was, I mistakenly also meant it was a redaction order. In the beginning, I thought it was both in one order. And I told him also that his comments did not go towards probable cause.
Okay. Well, that's true, isn't it?
Yes,
All right. And did he agree with you?
no,
Okay. Would he sign the acknowledgement that he had been given this EES observation report?
no, both him and his spam rep both stated to me that they refused to sign.
Okay.
I told him I understand that was well within his rights not to sign. But that he had to comply with the direct order just like I did.
Okay. Did he comply?
Yes,
And he would have been subject to what if he hadn't?
same as me, would have been subject to insubordination charges.
Well, he wasn't ever, was he?
No.
Never suspended, never terminated, never getting a written reprimand, anything like that?
No.
And you're familiar with the EES system?
Yes,
Is this where the observation report come out at some point in time?
after 1 year.
And do they have the opportunity to write their own version of what took place if they choose to do so?
And have it placed in the file, yes.
Was that done by him?
I don't know.
Good. Now, had you participated or had any conversations with the district attorney's office prior to your interaction with Trooper Seeger?
Absolutely not.
Joe Early or Jeff Travers never told you to do anything, did they?
No.
Incidentally, do you know Mr. Travers, ADA Travers?
I know him in a working environment, yes.
Okay, socialize with him?
No.
You know the district attorney?
Well, except like a working environment. At scenes, we would run into each other.
Give us an example where you might have seen the district attorney or Mr. Travers at a scene.
If there was a major homicide or something, like the death of the jogger in Princeton, I would be called out to the scene and he would as well. So we would run into each other at a scene.
Right. Ever socialize with
Or
him?
a training, no.
And prior to this incident, did you know Ms. Bebo?
No.
Did you know Judge Bebo?
Nope.
Did you ever have any prior interaction with either person?
No.
Did you have any interest in providing them, either one of them, with any unwarranted benefit or privilege as a result of your conduct in this case?
Absolutely not.
Did you in any way try to provide anything different to them in the way of this redaction that would have been different from what you would have done for any other person?
Absolutely not.
You know what a DRE is?
Yes.
What's a DRE?
A drug recognition expert.
Okay. And is that a recent occurrence in terms of developing these the DRE program?
It was when I was on, yes.
Okay. And there was discussion yesterday about the removal of the DRE report that was done of Ms. Bebo from the administrative journal.
Yes.
You familiar with that?
Yes.
And what, not to be repetitious, but what's the administrative journal?
It's a daily log that's kept both in the headquarters and in all the substations across the state.
Okay. So does the public have access to that?
They have access to parts of it, yes.
Okay. So, for instance, our reporter, Mr. Petroshan from the Worcester TMG, he would have access to go in there and have a view of whatever's contained in that?
A copy provided, yes.
Copy.
As far as I remember, yes.
So he's not just like scribbling down what's in it, right?
Correct.
And did you at some point learn that the substantive same or comparable information that was in the impounded arrest report had been put into the administrative journal?
I did. I don't remember how I learned that, but I was made aware of it, yes.
Okay, regardless of how you found out about it, can you tell us what you did once you found out that this DRE report, the contents of it, had been put into a public access journal?
I went down to the Holden substation and I pulled the actual logbook where they keep copies of it from that day that contained that information.
Okay.
And I went back upstairs onto the computer and I took it out of the log, printed a new copy without that information and put it back in the journal.
Okay. And tell us, Honor, why'd you do that?
Several reasons. There was an impoundment order in place. The courts had deemed that the content of the report was to be impounded and
You
kept
said
from
the report, just make sure we're talking.
the Ali Bebo arrest report.
Yep.
The judge deemed there was information contained in that report that could be prejudicial, which is why it was impounded. And that information was contained in our public daily administrative journal. I also believed it was a HIPAA violation, because there was a lot of personal health information in there about Ali Bebo.
Such as, I don't want the actual content, but
Weight, teeth, height, blood pressure, urine analysis.
that's all put into this DRE, which was put into the administrative public access,
Correct.
in addition to some or all of the comments that the impoundment order was based on. Do
Yes.
you think you're doing anything inappropriate by having that removed?
Not at all.
And what were the consequences? What would the consequences have been had you not taken that action?
I would have been in violation of the impoundment order, was my belief.
Well, you're in charge of the Troop C, right?
Correct.
Impoundment order went to you, right?
Correct.
What'd you do with it?
With,
Did you try to comply with the impoundment order?
yes.
No. I asked you what your tonality was when you met with Trooper Sevier and his troop rep. Do you know how long that meeting was?
I don't recall if it was more than 15 minutes, I'd be surprised.
Okay. Do you know who violated that impoundment order?
I do not.
It wasn't Jim. Given the same set of circumstances today for a young woman who was addicted to heroin, whose father wasn't a judge, would you have done anything differently?
No.
When you spoke to Trooper Sevier, were you aware of what the interaction was that he had between the bail commissioner and himself that night of the
I did
arrest?
not, no.
You know about it now?
Yes.
You know about the various factors that go into determining what bail should be set at?
Yes.
Did community relations, family ties, part of that analysis?
That's what I've learned, yes.
And did you know that that he withheld the information from the bail commissioner, that her father was a judge?
I did not know that at the time, no.
You know it now, right?
Yes.
And did you also know that the judge, her father, actually asked to have her defaulted the following day because she wasn't going to be at her arraignment, she was getting treatment?
I did not find that out until this hearing.
Does that sound like he's looking for special treatment?
No.
Did you give him any special treatment because he was a judge or his rank or his position in society?
Absolutely not.
Thank you.
Can I have that back, please? Okay, thank you. Okay, thank you. Let me just ask a question. Thank you. That's been, one of the commissioners, as I've indicated, are listening in and they have some questions. Here's a question. Have you ever before this incident been ordered to revise a police report?
I have not been ordered to revise it, but I have ordered others to revise reports.
Okay, you've ordered others to revise. And have you ever had a case similar to this before? An
Not at
OUI
all,
case?
no.
Okay. Yeah, do you want to?
Well, I just was waiting to see what the question was, to see if I needed to follow up.
Yeah, that's right. Do you want to follow up on that? Sure.
When you say you've never had a case like this, you said you had OUIs, 100 OUIs, right?
Correct.
What distinguishes this case from other cases is that there is a breach of the impoundment order. Isn't that true?
Objection.
Well, that is leading, so
Well-
is that your objection?
Yes, it is, thank you.
Okay, yeah.
When you were asked the question, whether or not you ever had a case like this. What is there about this case that's different from other OUIs you had?
The commentary that was included in the report, the impoundment order that I received on my desk from the court.
Did you feel you had any other choice to do nothing, given the fact that this had been impounded because of potential pretrial publicity?
Objection.
No, you can have it.
Can you repeat the question?
Can I have it repeated?
You lost me when you did it the first time.
Did you feel you had any other choice to make to do nothing, given the fact that this had been impounded because of potential pretrial publicity?
I felt I had to act for several reasons, the impoundment order and the order from Lieutenant Colonel.
Thank you, sir. Skyly or Mr. Rasconi?
We're following yesterday's protocol.
However you folks want to do it is fine with me. Mr. Rasconi?
Thank you, Your Honor, may I inquire?
Sure.
Good morning, Ms. Anderson.
Good morning.
You mentioned you had reports revised under your own direction.
Yes,
So at some point, you were a supervisor just like Sergeant Conant was, right?
correct.
So if you're in Sergeant Conant's position, going back a little bit in your career, trooper makes an arrest, gives you the report, and you look at the reports and you either approve them or send them back. Is that accurate?
Yes,
If you saw this report as a sergeant and you had to approve it, what would you have done?
sent it back for revision.
And why would you have done that?
My training, those statements do not belong in a report. They have nothing to do with probable cause. And they were inflammatory and vulgar, in my opinion.
And you've been employed in an overlapping, I guess, timetable or timeline with Colonel Racine, Deputy Colonel Hughes, Colonel McKeon, right?
Correct.
So, and you've heard all this testimony about the direction of the department and even the legislator about opioid addiction and how the department's gonna treat people, right?
Yes,
Is that consistent with your experience?
yes.
And throughout this whole set of events that bring us here, you never talked to Colonel McKeon directly, did you?
No.
You just reported to Colonel Racine.
Correct.
And I just want to ask you, you said code 7. It sounds like it'd be an inconvenience, but is it inappropriate for a trooper to be called back to the barracks under a code 7?
No.
Sergeant Conant complained about being brought back to the barracks?
Not to me, not that I'm aware of, no.
To your knowledge, did he join any of these lawsuits?
He did not.
And I just want to touch on something that was referenced yesterday about DRE reporting and examination. So just so everybody's clear, an arrest report, such as the trooper in this case, and a DRE report in this case are two separate and distinct reports, right?
Correct,
They have two different authors,
correct.
and those authors of the reports have two different sets of training, fair to say?
Yes,
So Trooper Ray has been trained under the Drug Recognition Expert Program.
correct. She has protocols that she has to follow during her exam and with the report that follows.
And that exam is pretty different from a regular DUI field sobriety testing protocol, right?
Extremely, yes.
So the DUI stuff is, they reference standard field sobriety tests. There's only 3 of them, right?
Correct,
And then there's some other defer to detention, say the alphabet and count backwards and stuff, right?
yes,
But DRE is different, right?
yes.
They have actual, basically what sounds like a medical exam, isn't it?
Yeah, they come in with a medical bag that has like urine specimen sample collection,
Did they ask him if they're on prescription meds?
yes,
Did they take the blood pressure
yes,
to check the
as far as
pupils?
I know, yeah.
Oops, he dilated or
Temperature.
restricted? Yeah. So, quite different from an arrest report is a DRE report.
Yes,
Now, the administrative log we talked about a little bit. Appropriate things to go in an admin log would be such to the effect of Trooper Ray arrives at barracks with someone in custody, right?
yes, that's the only way I've ever seen it
Right.
until this time.
Or Trooper Ray arrives to do a DRE exam. Trooper Ray conducts DRE exam. Trooper Ray releases so-and-so to a Q5 supervisory check or something like that, right?
Correct.
It's basically just activity, but it's not reported, right?
Right.
So, and again, you said that this is public stuff. Anybody can ask what the activity log was, right?
Yes,
Kind of like the police blotter that you see in the paper all the time.
correct.
So, and again, your concern wasn't necessarily any specific content with the report, but it was that it's going to be broadcast to everybody in violation of an impoundment and even a potential HIPAA violation, right?
Correct.
The trooper's report, though, wouldn't necessarily have those same HIPAA issues, right?
No.
Okay. And to your knowledge, Colonel McKeon was never advised of anything about this administrative log business, right?
No, not at all.
You never told him.
No.
And you told Colonel Ristine, though, because he is your direct superior.
Correct.
And you didn't tell Colonel Ristine to run it up the chain, though, right?
No.
You told him that it's going to be taken care of here. Just no need to belabor this any further.
Correct.
And to your knowledge, Trooper Ray is pretty new at the
Very
DRE.
new, it's a DRE, yes.
Do you know, was it her first one? Do you have any idea?
I don't.
But again, it's a different process than what she was probably used to doing until she became a DRE expert.
Yes.
I don't have any further questions.
Okay, thank you, sir. Ms. Schuyler?
Good morning.
As you know, I'm Tom Kiley and I represent District Attorney Early. Attorney Risconi just asked you about Ms. Ray. You said she was very new as a DRE expert,
If I remember correctly, yes.
a young trooper.
Yes.
When you were removing the material from the administrative journal, is it something that you discussed with Ms. Ray after the fact?
After,
And did you explain to her why you had removed it?
yes,
Is that a teaching moment for you?
it was.
Is that teaching moment the kind of thing that you do with the officers under your command regularly?
Fairly regularly, yes.
Sergeant Conant, do you know Sergeant Conant, correct?
Yes,
You worked with him over the course of time.
yes,
He was a relatively new sergeant at the time that this matter was before him,
he
correct?
was.
That he had not undergone the in-service training for sergeants at that particular point in time, had he?
That I don't know.
Did you attend a meeting conducted by Lieutenant Colonel Ristine on or about September 26th of 2017 that dealt with poor report writing?
Along with other issues, yes, but there was a lot of talk about report writing.
Was there a meeting with the sergeants at that meeting?
Sergeants were not at that meeting.
That would have been troop commanders, basically?
Yes,
All of the troop commanders in field services?
yes,
And then to the extent that there was an agenda item that was raised at that meeting over the course of time, it would be addressed by the troop commanders, correct? That's the way a paramilitary organization works.
correct.
Paramilitary organizations have their own codes.
We do.
9 o'clock in the morning is 0910 within the paramilitary organization.
Correct.
code 7 is simply a report to barracks, correct?
Yes,
The question came up in your direct examination by your counsel about a direct order on the effect of a violation of a direct order, correct?
yes,
Direct order to which you were responding was one that you received from Lieutenant Colonel Riskeen, correct?
correct.
Was there a discussion that you had in the presence of Trooper Gilbert or Trooper Sevier or Sergeant Conant about the origination of that order?
No.
Was there ever any suggestion made that by you that the order came through Secretary Bennett?
No.
That it came from anybody other than people within the paramilitary organization?
The only one I knew it came from was Lieutenant Colonel Riskeen.
Did Lieutenant Colonel Riskeen strike that? In the meetings that you occurred, was Trooper Gilbert in both with Sergeant Conant and with Trooper Sevier?
I'm sorry, I don't understand the
I'll
question.
look for other questions. Was Trooper Gilbert representing both the sergeant and the trooper?
At the EES phase, maybe. He was not in the meeting with us. Sergeant Conant was not.
So the issue, you were asked on a direct about the consequences of violating a direct order, correct?
Yes,
And there was you used the word insubordination.
correct.
Did insubordination come up in the meeting with Trooper Gilbert and Trooper Sevier?
Not from me, no.
From whom did it come up?
Trooper Sevier was talking kind of like backed up from my table off the cuff with his representation. And I don't know if it came up then. I did not bring up anything about insubordination.
You talked about SAMs in your direct examination, correct?
Yes,
That was situation awareness.
yes,
When Captain Johnson brought the report to you, he was bringing to your attention a situation that existed, correct?
yes,
And in that, on the day that you received that information about that situation, you acted upon that situation, correct?
yes,
And you reported up the paramilitary chain of command to Lieutenant Colonel Riskeen that what the action was that had been taken, correct?
I'm not sure I understand where you are.
I think
He contacted me and
He
then
contacted
I
you.
contacted him
you
as it progressed.
and at the end of
As
the
his order
day,
progressed, yes,
and at the end of the day, you informed Lieutenant Colonel Riskeen that you had taken action pursuant to the order, correct?
correct.
You were asked again on direct, I believe, about whether you knew who violated the impoundment order.
Yes.
Recall that? You know the impoundment order was violated, correct?
Very obviously, yes.
And it was very obvious because why?
The news media attention, a certain online website had a full copy of the report, the original report, or alleged he had it.
And did the news media indicate that it had come from the state police?
Yes,
you expressed a concern with respect to the impoundment order, the judge had found that it might generate prejudicial pretrial publicity, correct?
Correct.
As a consequence of prejudicial pretrial publicity, potential dismissal of a case.
I'm sorry, I didn't catch the last.
I'm sorry. Do you know that a violation of defendants' rights with respect to prejudicial pretrial publicity jeopardizes the case?
Yes, could lead to dismissal.
You used the word gist in describing the document that came before you. Is that a code word within the state? Is that another paramilitary phrase?
I don't know if it's paramilitary, it's just how we were trained. You write a gist, it's same as the report, you write a gist of what happened, what you did, what you observed.
Just the facts,
Correct.
nothing extraneous.
No.
And that was the subject of your training as you rose through the ranks, correct?
Correct.
And that was a concern that was expressed to you as troop commander on September 26th, 2017.
Yes.
You were asked about what made this case unique. The media made this case unique, didn't it?
Yes.
Thank you.
Thank you. Mr. Bourgeois, you have any questions?
I have no questions for this witness. Thank you, sir. I have no questions.
Hold on, we can't hear you. I noticed that there's a.
Can you hear me now?
Roy, turn up your volume.
His microphone up, may not be on, because it doesn't look like he's actually muted.
How's that working now?
Not at this time. Was that not at this time?
Very good, lip reading.
Thumbs up,
Okay.
thumbs down.
You
Can you put it in the chat?
No, he said no.
Oh, okay.
You know what I'd like to do, just in the interest of time, because I'm assuming he doesn't have a lot of questions, and I'm not gonna foreclose him from asking any questions, but I'm gonna ask the petitioner to do their cross-examination, and then I'll go back to Mr. Bourgeois after a break, allowing him and Arthur to see if they can correct this problem.
Would
Okay,
it be okay to take a brief break before cross-examination?
sure, you want a brief break? That's
That'd
no,
be great, thank you.
okay, that's no problem. Okay, thank you.
How long, Judge?
Okay, 15 minutes?
Perfect.
Is that okay? Okay, so we'll be back at 11:45.
Very good.
Okay, thank you. And, hey Arthur, during this interim, perhaps you could resolve his problem
So
with
it's a little weird, so
attorney.
attendees, everybody who's participating here,
Is this any better?
so that means there's a hardware issue here,
Okay,
yeah, so everybody else can hear them,
so everybody can hear Attorney Bourgeois except us?
not us.
Okay, see if you can correct that problem.
Yep.
And I'll be back. Thank you. Apparently, thanks to Mr. Shea, Mr. Bourgeois, their problem has been resolved, as I understand. All that little pin is still there, so.
Oh, that just needs-
Attorney Bourgeois, can you hear us?
Been resolved if you can hear me.
I can hear you. Okay, so do you have any, Ms. Major, can you come back, please? Thank you. Okay, Attorney Bourgeois, and I would ask you to, because you're probably going to be looking at him when you answer, so just keep your voice up so the court reporter
Okay.
could hear you, okay?
Okay.
Okay, thank you. Okay, Attorney Bourgeois?
I have no questions of the witness.
Okay. Thank you. Okay, Ms. Mahran.
Thank you.
Excuse us a moment, please.
All set?
Yes, thank you.
May I inquire?
Please.
Good morning. Just one moment. Major Anderson, do you remember on October 26, 2017, you sent a text regarding a Turtle Boy blog?
I sent one?
Yes.
I don't recall.
Do you recall receiving a text about a Turtle Boy blog on or about October 26, 2017?
I did receive one. I don't recall who it was from.
Do you remember what the article's headline was?
No.
Do you remember whether or not your name was in the headline on Turtle Boy?
I don't recall.
Field services arrest reports are attached to the application for criminal complaint in accordance with Mass State Police practice. Is that correct?
Correct.
In February of 2018, you were still employed by the Massachusetts State Police, correct?
Yes.
And do you recall on February 2nd, 2018, that you spoke to Kevin Burke regarding the judge's daughter's arrest report?
Yes.
And you know that Kevin Burke is the former DA of Essex County?
I mean, I know that, but I didn't know him, or I didn't know that at the time.
Do you now know, or did you know then, that he had also been the Secretary of Public Safety?
I know now. I did not know that.
And Kevin Burke was appointed by then Colonel Kerry Gilpin to review the arrest of the judge's daughter and the report. Is that correct?
I don't know what he was hired to review.
But you've reviewed the report that Kevin Burke produced that was released on April 4th, 2018, correct?
I'm going to object, Judge. I don't know where this is going in terms of using Kevin Burke's report. I don't believe it's, well, first of all, it's using something that is a report, which is a compilation of numerous other interviews. So you have total whole hearsay. Whatever his conclusions are, they're his conclusions. That's not the issue here today. I don't have a transcript of her interview that was conducted by Mr. Burke and whether the other person was. It's a voluntary interview that she undertook.
Okay.
So if we're using the summary portion of what his conclusions and what was said or wasn't said, I object to that.
Have you seen that report?
Oh, yeah.
Okay. Yeah. What do you want to say, Mr. Conley?
I too have seen the report. Kevin Burke and Nancy McGilvery were listed as witnesses.
Okay.
I have been in contact with them.
Okay.
Anticipated that they would be called. They have not been at the time I made the contact fairly recently, had not been contacted by petitioner. And if we're going to now try and import things from a report that is objectionable, as Mr. Burke outlines, with them not having had any contact with the witnesses and me being unable, therefore, to get a handle on things, I object.
Mr. Rusconi?
I just add that, you know, their report, he's offering his opinion. His own words is my opinion. It's not involved in the chain of events. So I don't see how his opinion is relevant to the substance that we are deciding, which is a separate matter.
Well, that may be true, but you know, I'm not quite sure where Ms. I just don't know where Ms. Morong is going and,
Well, Judge, I'm sorry, I mean, I suggest she's going to use his conclusions or his opinions as to what various people could or should have done as a consequence of this situation.
okay, well, if she tries to do that, you can object, so, go ahead, Ms. Morong.
Your Honor.
Have you heard?
Oh, yeah, I'm sorry, yes, Ms. Bourgeois.
While I don't want to step in too far into Attorney Burke's area, it seems to me that this witness has been charged with a violation of the ethics statute because she did not disobey what she understood to be a legal and lawful order. It would seem to me unfair to judge someone based on facts that were or reports or things done after she acted. It would seem to me that petitioner should be showing something that we haven't heard yet that clearly shows that the order she was given was illegal. And anything after she acted seems to me not to have a bearing on that question, and in fact to be unfair. She should be judged, I would think, on the facts as they appeared at the time she acted, and not based on some politically motivated report that came in months or years later.
Okay, well, as I indicated, I'll let Ms. Morong ask the question, and then we'll see if she's going into uncharted waters or permissible
Actually, at this
waters.
point, I'd like to move into evidence disputed exhibit 25. That's Mr. Burke's report.
Objection.
Okay, hold on. Everybody will have an opportunity, so can I see that?
For reasons therefore, I would state that the Attorney General's letter, which is essentially a report of their investigation, is part of the record. I would state that that was after the actions in this case. And I would also state that the respondents have based many questions on the Attorney General's findings. So I don't believe it's any different to submit Mr. Burke's report.
Let me, you ready?
Yeah, thank you.
The Attorney General's report is what referenced its referral here.
Right.
Okay, that's why we're here. And they also had substantive conclusions that are important in terms of what, if any, unwarranted privilege was obtained. If we're gonna have an opinion poll, let's call the Boston Globe, let's call the editor and ask the editor what his opinion is. And that to use this now, and to try to cross-examine my client with an opinion that's not based upon tape-recorded information, but just an opinion, and it's a very political situation. Obviously, there's a different transfer of the role, who the colonel was after Colonel McKeon left. It is inherently unfair and improper to allow this thing to be introduced, let alone used for purposes of cross-examination.
Okay, well, I'm going to take this under advisement, so over the lunch break, I'm going to review it, okay? So I'm going to.
Judge, can I just?
Sure.
This isn't actually something that should be, no offense.
Yeah.
An in-camera review. Once you're reading it, read it. And, I don't know how you can unring that bell. But obviously, it's something that he has been critical of what was done here. And it's not substantively appropriate to have the report done after the fact when viewed with hindsight. And that's what this is.
Okay, well, I have to read it to determine whether I can admit it or not.
You're not gonna take my word for it?
Ordinarily, I take the words of all attorneys here, but given the conflict, I think I'll have to read it and review it, okay?
But is she going to be allowed to cross-examine with it?
Well, let me just listen to the question. She can ask it would be improper in my view to say, Mr. Burke did, not you, Mr. Burke, Kevin Burke, it said such and such. That would be improper, but it would not be improper to ask questions based on what he said.
I'm sorry, could you repeat
Well,
that?
why don't you just ask the questions and then we'll move along here.
Major Anderson, do you remember being interviewed by the Enforcement Division at the Ethics Commission?
Yes,
And do you remember at that interview, you were represented by Attorney Burke, who's with you today?
yes,
And do you remember that that interview was under oath?
yes,
And you told the truth at that interview, correct?
yes.
And do you recall at that interview, when you were asked what you reviewed before your interview, you stated the report of Kevin Burke and Nancy McGilvery? Do you remember saying that?
I don't.
Do you remember reviewing the report before your interview at the Ethics Commission?
I did review it, or read it when it came out, but I don't know exactly time frame.
So you read it when it came out, correct?
I believe so.
And it was a public document, was it not?
I don't know.
Did you see it referred to in the news or newspapers?
The advice of my attorney, I didn't read any newspapers or articles pertaining to the case. So I don't know, honestly, if it was a public document or not.
And Mr. Burke and Ms. McGilvery's report came to some conclusions, is that correct?
Apparently, yes.
And did one of the conclusions, was it that
I
once?
think this is what they're objecting to. I'm going to sustain the objection. If you want to ask questions about the underlying facts that Mr. Burke investigated, you're allowed to do that. But I think it's impermissible to say, or I'm not going to allow you to do it, to say, the report said X, what do you have to say about that?
Commissioner, may I have your basis for not allowing me to
No,
ask
I'm-
these
I'm not gonna give you
cross-examination?
I made my ruling, you asked the questions.
Well, it's my recollection that respondents have referred to things not in evidence in their cross-examen, in fact, have read things into the record, but you're not going to allow me to question Major Anderson on what the report concluded.
On what the report concluded?
Yes.
Well, okay, you asked the question and then I'll see what I'm gonna.
Okay. The report by Kevin Burke and Nancy McGilvery concluded that once Trooper Sevier's report had been submitted to the court and used to support the issuance of a criminal complaint, it could be supplemented but could not be revised. Is that what the report concluded?
Objection.
Objection and move.
What's that?
Objection.
Objection.
Yeah, you object. Well, as I said, that's what the report, I suppose, speaks for itself. This witness,
I'd like to move to have
she
the
hasn't
report
even-
submitted as evidence, Your Honor.
I understand and I've taken that under advisement, but.
Well, if I don't know whether it's admitted as part of the record and I can't inquire of this witness, my
You can
hands
ask
are
her any
tied.
questions you want based
These are the
upon the
questions that I
report.
want.
Okay, but, obviously, we're just not communicating here. So you ask the questions you want, and if they object, I'll rule on it.
Let's see. Do you recall that Kevin Burke and Nancy McGilvery's report found that you ordered Trooper Sevior to amend his report and remove statements that were relevant evidence of the crimes of which the suspect was charged?
That's a stage. You can ask her the question, the basis of their conclusion. You can ask questions about that, but you're not going to get into the conclusions of the. At this point, I may read the report over lunch and say, okay, it's going to be admitted into evidence.
If it's admitted into evidence after lunch, will I have an opportunity to address the witness and do further cross-examination?
Yes,
Thank you.
but I still might object. I may still sustain objections to that.
Major Anderson, I think on direct you stated you ordered Lieutenant Fogarty to issue an EES to Sergeant Conan and Trooper Sevior. Is that correct?
Yes,
You also ordered Lieutenant Fogarty to instruct Trooper Sevior to revise his arrest report.
correct.
Correct. Lieutenant Fogarty did not instruct Trooper Sevior to revise the report, did he?
No, he did not.
Instead, Sergeant Fogarty sent Trooper Sevior to you, correct?
Objection. It wasn't sergeant.
Did I say?
Sergeant, lieutenant.
Oh, I'm
It's a
sorry,
lieutenant.
Sergeant. Strike
Misspoke.
that. I gave him a promotion. Sergeant Fogarty instead sent Trooper Sevior to you, correct?
Misinterpreted what I said. He was a lieutenant.
Did Fogarty send Trooper Sevier to you?
Yes,
And you're aware that the Attorney General interviewed individuals in connection with an investigation they did about this matter, correct?
yes,
And you refused to be interviewed by the Attorney General's office, correct?
correct.
It was completely voluntary, correct?
My refusal?
No, whether or not you would be interviewed at the Attorney General's office, it was voluntary.
As far as I'm aware.
Okay. And there was no subpoena issued to you?
No.
And the notes of your interview with Kevin Burke and Nancy McGilvery, they were provided to the Attorney General's office, correct?
I don't know the answer to that.
Did you, can I ask that the witness be shown Exhibit 32? And I'll state that it's a letter from the Attorney General's office to the Enforcement Division of the State Ethics Commission.
Thank you.
Thank you.
And I'd ask you to direct your attention to page 2. There's a footnote at the bottom of page 2. And I'd ask you to just read it and look up when you're done.
Footnote number 2.
No, there's just one footnote, but it's on page 2 at the bottom.
The two individuals who
No,
did-
just read it to yourself.
Oh, okay.
That's okay, sorry. No, you're trying to be helpful.
Okay.
After reading that, does that refresh your recollection at all as to whether the notes of your interview with Mr. Burke and Ms. McGilvery, whether they were produced to the Attorney General's office?
Only that I'm reading it here, yes. I had no recollection of it.
Okay. And I think on direct, you talked about removing Trooper Ray's DRE report from the, is it the Daily
Administrative,
Journal,
yes.
the DAJ?
Do you still need this exhibit to
No,
refer
you can
to?
give it back, thank you.
Thank you.
And after you removed Trooper Ray's DRE report, that's when you told Lieutenant Colonel Ristine that you'd done so, correct?
I had spoken to him prior to advise him that it was in the DAJ, yes. And that it was being handled.
But you weren't ordered to remove the DRE report from the DAJ, correct?
I was not.
You took it upon yourself to take that information out of the DAJ, correct?
Based on a lot of circumstances, yes.
Now you, on direct, you talked a little bit about the impoundment order that you got.
Yes,
Now that was a legal document, correct?
yes,
And it was from the court,
yes,
and it was an order from the judge, correct?
yes.
It didn't order you to take any action, did it?
Specifically, no, it did not name me to take any action.
And you didn't consult with legal counsel at the state police about this impoundment order, did you?
I felt no need, no.
You're not a lawyer, are you?
No.
And your handwritten notes, I think they're Exhibit 12. There's no date on your handwritten notes, correct?
Correct.
There's no time stamp on them.
Just my handwritten time.
Can I ask that the witness be shown Exhibit 12?
Sure.
Thank you. And on the left-hand side where it says hand delivered, can you
Yes.
just read that portion, hand delivered?
Hand delivered to the ADA and defense attorney.
It doesn't say anything about delivering to the clerk's office, correct?
No.
Your entire conversation with Lieutenant Colonel Ristine, that's not verbatim put down in Exhibit 12, is it?
The entire conversation?
Yeah.
No.
Have you ever ordered an arrest report to be revised after the arrest report was submitted to the court and relied upon to issue a criminal complaint?
Thank you.
Can I have just one moment?
Take your time.
Thank you. Commissioner Kantrowitz, at this time, I have no further questions, but I would ask to suspend my cross-examination based on your ruling on whether or not the Kevin Burke report will be admitted
No,
into evidence.
she did not, she was not interviewed by Attorney Burke?
She was interviewed by
Okay,
Kevin Burke, yes.
she was interviewed by
She
him.
was.
Okay, and she made certain statements that are in this report?
That report, I think it speaks for itself. I'm not asking her about statements that she made in the report.
So you're asking about statements other people made?
I'm asking about the conclusions that the report came to, just like the Attorney General's letter came to conclusions about their investigation.
Okay, I understand that. Thank you.
Thank you.
Okay,
Your Honor, I had one or two questions based on, well,
yeah, well, I'll let Mr. Burke go.
I didn't see Mr.
Yeah,
Burke,
okay,
sorry.
so- okay.
Attorney Burke, I thought,
Okay.
I apologize.
Okay.
You want us to go now, Judge, or wait while you make your ruling? It just seemed.
Well, you know, if she's, you know, I just don't, maybe I just don't understand, you know, the report speaks for itself. And I've let most of this information in, and candidly, I'm inclined to do it here. What I'm concerned about is you just asking her, you know, the report concluded X, you know. What's she gonna say? Yes, no, the report speaks for itself. Why do you have to ask her questions about what the conclusions of the report?
I Judge, essentially what she's asking is, did he conclude this? Okay?
I think I've asked that question. That's all right.
I know.
I know that's-
I'm in full agreement, but that doesn't make it admissible.
I agree, you know, I agree with you, but as I've indicated, you know, I'm one of 5 commissioners and, you know, I think my fellow commissioners have like preferred seeing all documentation. That's why I've let it in. So I'll take a look at this over the lunch break, you know, my inclinations, I'll probably let it in. What I'm probably not going to allow her to do is to say that the report concludes such and such of this witness. You know, the report speaks for itself, so I just,
Well, then if that's your inclination, you know, we're gonna kill too much time.
kill too much time with what?
I'm separating this out. I'll withdraw, if you're going to introduce the document, because that's the read I'm getting.
Right.
If you're gonna allow the introduction, I'm gonna step back and she can ask questions based on whatever questions that she wants to ask with your permission.
Yeah, but I indicated I'm not going to allow her to ask questions about the conclusions of this report. The report speaks for itself, so
Having ruled then, are there any other questions that she wants to ask?
oh, I see what you're saying. I'm okay, Ms. Moran, are there?
Have you admitted,
I'm inclined to admit it, and I'm inclined to not allow you to ask questions about, did the report conclude X, Y, and Z of this witness?
I think what I would say is if you admit it, then I would be inclined not to ask her about what results the report came to. But I think I need to know whether or not it's coming in as evidence or not.
Well, regardless, you're not asking any questions. right? If I don't allow it and you're not asking questions, if I do let it in, we've determined the document speaks for itself and you're not gonna be asking any questions. So regardless, you're not asking any questions.
Well, I'm not asking any questions at this point regarding this. I think if any other questions are asked by the respondents, maybe additional questions could come up.
Oh, sure,
Okay.
absolutely. You absolutely have that right, absolutely.
All I was trying to do is try and move us forward.
I appreciate that.
Okay. You were asked about the DRE report. Um, Do you know whether or not there was any additional training provided to Trooper Ray and or others who were recently introduced to the DRE program after this information was put into the Daily Administrative Journal?
I don't know about specific training. There was an email put out to all DREs regarding this specific event and how it did not belong in a log, and they had protocol they had to follow for the report. And Trooper Ray responded to it,
How'd she respond?
something to the effect that that was on me.
Okay, me, you, or me, her?
Her.
Okay,
That was on me, I didn't realize it, or something to that effect.
okay. That it should not have been put into the Daily Administrative Journal?
Correct.
You were asked whether or not you had refused to be interviewed by the Attorney General's office.
Yes,
You have a lawyer?
I did.
Who is it?
Attorney Burke.
And were they investigating everybody for potential criminal activity?
I don't know.
Did you later learn that they determined that there was no criminal activity?
Yes.
So that was one of the conclusions of the report, that there was no criminal activity?
Yeah.
Okay. I'm just saying that, you're using your conclusions.
Well, I'll tell you what.
It's conclusions,
I'll
so,
withdraw the question.
well, no, yeah, it's, as I said, the horse might have left that barn, so,
I'm just lassoing it and bringing it back. Yeah.
okay, no, as I said, ask whatever questions you want.
You're gonna read it anyhow, so.
Yeah, the reality is, I think that for the purposes of this hearing, I have basically let in just about every document. I think every document from all sides. So I'm inclined to let this in also, frankly. I'm going to read it over lunch, but my inclination is I'm going to allow it in, okay? But I'm not going to allow her to ask this witness about the conclusions of the document, which speaks for itself.
I'll leave it at that.
Okay.
I better sit down before I let any more horses out there.
So, okay, Mr. Visconti.
Thank you. Major Anderson, you were just asked a few moments ago by Attorney Moran if you'd ever happened to revise a report that had already been submitted to the clerk's office, right?
Yes.
And you said you didn't, right?
Yes.
But you also said, and we're going back a little while ago, when you were a sergeant and you saw a report like this, you wouldn't approve it, right?
That's correct.
So, but this report did get approved, right?
Yes.
So if the other sergeant in this situation, it doesn't get to the clerk's office, right? Isn't that the whole point of this supervision directive from the colonel? So he doesn't get a phone call from the district attorney complaining about language of the report because the supervisor should have stopped it in the first place.
That is correct.
And the reason why we're dealing with this is because that supervisor didn't stop it.
That's correct.
Thank you.
Getting that information to the colonel was the purpose that Sam's served, correct?
Yes.
No further questions?
I have a question.
Yeah. Attorney Bourgeois, what do you have to say?
Yes. I guess it's afternoon there. Good afternoon, Ms. Anderson. You and I have never talked before, is that correct?
Correct.
I'm going to ask you a couple of questions about what I call the facts and the circumstances as they appeared to you at the time you acted. So we're talking about what you knew and what you understood at the time you took certain actions, as opposed to something that you may have learned later on, okay?
Okay.
All right. My first question is, were you aware of anything at the time you acted that led you to either believe or suspect that the orders you were given were clearly illegal?
No,
You sat through this entire hearing, is that correct?
yes,
Have you heard any testimony or seen any documents in the time that you sat through the 8 days of this hearing that led you to believe that the order that you were given was clearly illegal?
Objection.
Well, she
When
can,
you read the so-called Burke report, did you learn any new facts or new circumstances that you didn't know previously that led you to believe that the orders you were given were clearly illegal?
no,
Thank you, that's all I have.
okay, Mrs. Moran,
Nothing.
okay, so there's nothing, okay. Ma'am, thank you very much.
thank you.
Okay. What I propose doing is addressing the early emotions and then perhaps taking the lunch break, or do you prefer going to 1 o'clock and then taking the lunch break? I'll whatever the parties are
I
comfortable
think
doing.
procedurally, whatever you want to do is fine with me.
So, so let's just deal with these motions here, and then we'll see how much time we have. So, okay, so you all received a copy of Attorney Sullivan's opposition to the introduction of the judges. So, what would you, I don't know, who's speaking for you? Okay, Ms. McDonald, what do you have to say?
This is the opposition from Attorney Sullivan.
Correct.
Good afternoon, Presiding Officer Cantor. John McDonald for the petitioner. We're again asking that you admit the Attorney General's transcript of Judge Despotopoulos, that December 8, 2017 Attorney General's transcript. Just a couple of points. I've had a chance to read Attorney Sullivan's written statement that he provided pursuant to 268B, Section 4, I believe it was. I would just note that Attorney Sullivan was present during that Attorney General's interview with Judge Despotopoulos on December 8th, 2017, and he didn't raise any objections to any of the testimony at that point. So I respectfully
You say he's foreclosed from raising it later?
suggest that any type of objection he had would be waived at this point because it was already
I understand.
testified by the Attorney General's office, and the commission, I think, could certainly. That's the first thing about the judicial deliberative process. That could be redacted. I've read the transcript, as I'm sure you have, and I didn't see anything that would even fall within that objection. Anyway, it would be waived. As far as his other objection about cross-examination, this and that, I'd suggest that any inconsistencies, we're not raising any inconsistencies or questioning anything that Judge Despotopoulos did. He was, a witness that we called, and we certainly weren't trying to say he did anything wrong in this situation. If there are any inconsistencies in his testimony in the Attorney General's transcript different than what he testified here, then I think the full commission would have the transcript and they heard his testimony and they would be able to resolve any inconsistencies. Again, it's not that we're trying to make any issues with any inconsistencies in it. So for those reasons, and as well as—
If there's no inconsistencies and he's already testified, so why should the document be admitted?
It's really just to give the commission a full record. Trooper Sevier testified and his transcript came in as well. I think, as you noted, you pretty much let everything in. There isn't really anything in there that the commission shouldn't see. I'd note also that it was on Respondent Joseph Early's exhibit list as item number 1. So it was something that the respondent as well, he wanted, was a disputed exhibit, and I guess just in the
So Mr. Kiley initially wanted this in?
It's on Respondent Joseph Early's exhibit list, I believe, is exhibit 1.
There are awful lot of things that I have asked to be considered, 643 facts, a number of transcripts. One of the things I may do today relates to another. And I have advocated at different points in time that all of the transcripts come in, but we haven't been able to agree to it. But I did list that on my list.
Well, what's your position now on this?
Well, may I?
Because I
don't mean to
No, that's all I had to say essentially.
That's what I said.
Everything, a lot of other references come in, and I suggest that this should come in as well.
So, because it was my memory is that the respondents objected to this document coming in.
I think that there have been a lot of objections, some at different points, because not everybody on the respondent side, despite the commission's decision to consolidate these matters, not everybody has the same interests. Yes, I have advocated for a lot to come in. And in some instances, an awful lot has come in.
Yes.
I'm the person who brought section 4G to the attention of the court and brought this particular issue up. Section 4G has been in the statute since it was created. It applies to individuals whose names are brought up in adjudicatory proceedings, or maybe Judge Despotopoulos is clearly one of those people. He's entitled under the statutes to make a statement.
Can I just short circuit you for a sec? Do you want this document to come in or not?
Honestly, I don't care.
Okay.
So, but I want to be heard on 4G, because this also relates to another thing that I am going to be, depending, if this comes in, right? The statement is the statement, it comes in. If depending upon how you rule, I am also going to be seeking to put a transcript in today. It is an exhibit of another judge interview, and I've signaled as much through providing the information through Arthur in the morning. I am going to be moving that, and again, I think the important thing to recognize, again, there's judicial privilege. There are things that are in the commission's statutes, and I don't get to talk to the commission about this stuff. I get to talk to the legislature and all of us, that are designed and have been from the beginning to protect people who have not been, against whom no order to show cause has been issued. We've all been through that already in this matter. They exist, they should be followed. The statement should be evaluated for the purposes articulated in the statutes. And if the transcript comes in, Mr. Bourgeois is going to end up suggesting that it's so that they can cut and paste and make an argument later. From my perspective, if it all came in, I would be happy.
So let me just ask you, just for my edification, what's the disputed exhibit number, so I can just take a quick look at it?
I know that I think on the disputed exhibits, it was one, wasn't it?
The list I had was exhibit 1, I believe.
That's disputed exhibit 1? Okay, can I just take a look at that? And what's your position on that coming in?
That's the transcript, I think, of.
Yes.
Well, that's what I understand from the questioning. I originally listed it as a potential exhibit with many others.
Right.
Is that what we're talking about, the despot?
Yes, I believe so. So I believe we moved it in,
Right.
after Judge Despotopoulos had testified in lieu of redirect. And then my recollection is the respondents objected at that point.
Right.
And then at that point, Attorney Sullivan also objected.
Yeah,
which was-
but I might have misheard you, and I apologize. Is there another document of another judge you want to get into evidence?
Yes,
Yeah, what exhibit is that?
it's disputed.
6, okay, so that's what I'm,
What judge?
we don't know what
House.
that's about.
well,
Judge-
we'll get to it. Take it easy, we'll get to it. This is Judge Allard Medeus. Now, what's your position on that?
I don't think I have a position yet. We just heard about that for the first time now. I'd have to,
It's on our list.
guess, just take a look.
Okay, well, I'm gonna,
Um,
but, and also, I'm gonna have the same problem with this that Attorney Sullivan flagged for the other judge, okay? So, what I'm inclined to do to short circuit this is to give you the opportunity to meet with Judge Sullivan and your brother counsel here and go through the document and redact what he finds objectionable, a deliberative, process. And then after that's all redacted for both statements, then I'll rule at that point.
Maybe I can clarify in this regard. I'm not sure the deliberative process, Judge Allen Medeus is not a judge who acted on this matter.
Okay.
Exactly, which is.
So the deliberative process issue would not exist in this
Okay.
instance. His transcript would be like all of the others that we're talking about.
Well, since, I assume Judge Sullivan represents both judges on this case. So I would ask in courtesy to him that you just, give him a phone call, tell him what's going on and ask whether he has any objections. And then if he does, we'll take it from there. And then on Exhibit 1, if you can redact, the problematic parts, then, we'll come back again and discuss it.
I think my brother counsel just indicated that Judge Allard Medeus has played no role in this
No, I
matter
agree.
that's before the commission.
No,
So-
I didn't make such a representation. I said he did not act on he's not one of the judges who ruled, the 2 judges who ruled. And
So-
therefore, that's who has a deliberative privilege.
Well, and regardless, it's just, as I say, this is a courtesy to Attorney Sullivan to give him the opportunity to weigh in on this, which I think is just fair, okay?
Including whether or not Judge Allard Medeus's transcript is even relevant to any of the allegations in the order to show cause. Because, the order to show cause are public, and Judge Allard Medeus didn't play any role in any of the
Well,
allegations in the order to show cause, so
I
it's
don't want to be,
unclear why his transcript would be at all.
so you're objecting on relevancy grounds?
That too.
Okay, well, as I've indicated, I've let in a lot of documents and I've let in a lot of documents, so the relevancy is probably, given the tenor of this hearing, is probably not gonna fly. So I've indicated what I'm asking you to do, and I ask you to do it, okay?
Can I just state my position on the record?
I think I know your position, but you can, I think I know your position, but
You want to tell me what it is?
no, the floor is yours, Mr. Burke. I'll never speak for you. Go ahead.
I'm just gonna be consistent. I don't think those statements from the AG's office come in.
Okay.
In terms of relevancy, he was interviewed, so he has to have some relevance into the case. So, and just a clarification, Trooper Sevier's transcript was used for the purpose of confronting him with conduct. It wasn't introduced by me wholesale. And I'm not sure how, when I asked this question, are you using the transcript for the purpose of for impeachment, corroboration, or to show it's a prior consistent or inconsistent statement? I still don't know what the purpose is for introducing them when their trial testimony is consistent with what they've said before. So to introduce that without having a predicate basis for doing so, I think is in violation even for, adjudicatory hearings.
Okay, that's fair enough, and you've been consistent, so, Mr. Brusconi, you want to be heard?
At this point, I'm of the mind that, like you said, you've let plenty of stuff in, and I agree with much of what Attorney Burke said, in that if it's being used to impeach or off the prior inconsistent statements, things of that nature, then yeah, then it's useful. But I'm at the stage of doing business is being done, and I understand what's going to happen.
Right.
But I do agree with most of what Attorney Burke just said.
Okay, very good. Ms. Bourgeois, you want to be heard?
As I understand, the question that's on the table is whether the presiding officer will admit the unsworn interview transcript of the Attorney General interview of Judge Despotopoulos. And I think that document should be excluded for several reasons. Number one, the petitioner had an opportunity and took the opportunity to interview Judge Despotopoulos on oath. They knew that the earlier document was not done on oath. They knew that the quality of the transcript was questionable, and all of the Attorney General transcripts have questionable transcription quality. And presumably they asked and confirmed the questions that they thought was important. When the judge testified, he was shown portions of his testimony in front of the petitioner and had a fair and open chance to respond and to say, yes, that's what I said, and no, that isn't what I said. But after he's gone to take an unsworn transcript of questionable quality and add another shovel to the pile that petitioner will cut and paste from in its post-trial brief is not fair. That document should be excluded. It has no place in the hearing.
Okay, I appreciate it. You've been consistent also on this. So, okay, so I've indicated what I'm going to do, and I'll wait to hear back from the parties. The next,
Sorry, I just wanted to confirm that the next step is we're gonna reach out to Attorney Sullivan to identify what specific portions of Judge Despotopoulos' transcript that he would like redacted.
correct, and you're going to reach out to him about the other judge, because he's going to.
Attorney Colley was gonna handle that initially, and I'll handle the Judge Despotopoulos redactions.
Why don't you you're going to talk to Attorney Sullivan, right? Fill him in on everything that we're discussing here. So it's stupid for you to call him. And then, 20 minutes later, Attorney Kiley's gonna, just let him know exactly what's going on. And Attorney Kiley is free to speak to him, obviously.
A conference call would be fine with me too.
Okay.
Okay.
And the next, motion for closing arguments before the full commission. I've kind of indicated what I want to do. If you want to be heard again, Ms. Pruitt, I'll be happy to hear from you. But
Thank you, Commissioner. We filed this motion based on your indication that you wanted to have closing arguments tomorrow. This is a motion to the commission as authorized by 930 CMR 1.0110F. So it is actually, that section says the commission may, upon motion of a party, or upon the advice of the presiding officer. So making a distinction between the commission and the presiding officer, grant the parties an opportunity to make such closing arguments before the commission. And so this is our formal motion to be able to do that. We think the commission would benefit from having the transcripts of the hearing. We are unaware that all of the commissioners have had an opportunity to hear the so far 8 days of testimony. They should have the opportunity to have the transcripts and have the parties brief and argue the case so that they can formulate their questions based on the 8 days of testimony. So we respectfully request that our motion be submitted to the commission for its decision.
I appreciate that. I'll just note that you're not at any disadvantage that you're the other four counsel, everybody's in the same boat on this one, right? You're not at any disadvantage. They're in the same position as you are. They don't have an opportunity to review the transcript of 9 days, so they would have the same concerns you have theoretically, and they're willing to proceed.
Yes, but it's not just that all the parties are at a disadvantage. The commission that is going to decide this case is at a disadvantage because the commission, the 5-member body that is going to decide this case, does not have the transcripts, The arguments have not been briefed, and they don't have an opportunity to formulate the questions that they would do typically in any other adjudicatory proceeding as you would do in appellate arguments. That is how the closing arguments are done. And so we are requesting that our motion to the commission, which our regulation allows us to do, that it be considered by the commission.
No, I appreciate that. I take it the four respondents want to do it tomorrow if possible.
Judge, this is not a difficult case. You either got the evidence or you don't. You know, and whatever it is, it is. The case is the case is the case. It's gonna take me 15 minutes to summarize what has been kicking around for 4 years. You've heard it, you're an experienced judge, hundreds of cases. You had participation from the commissioners who want to participate. You've had one who sat through here most of the time. Yeah, there's been multiple questions asked. We don't know who's asking what questions, but nobody's being prejudiced here. I don't need a transcript to know where I want to go. And to say that we're gonna suspend this and continue this for what, 3 more months for the no offense, but the transcripts be, processed. I mean, you take notes. It's ridiculous. Let's go tomorrow.
Okay, I think your answer to my question is we want to go tomorrow.
Yes.
Okay.
We want to present, I want to present my view of the evidence tomorrow while it's fresh in my mind, not 3 months down the line. The commission's rules make you the presiding officer. You were designated. You have the authority to decide on all procedural matters. That's in the rule. The only thing that you can't do is give us a clear bill of health. You could not, under the provisions of the rule, and it's only that thing that you can't do. In this instance, after you, who have the deciding, making power with respect to how the proceeding is going to go, have made a decision that the petitioner does not like, they want the commission to overrule it. The authority on this matter, under the regulation, is controlled by something higher up within the rules, other than the last sentence of paragraph 10. Section 6, subsection 6 controls, you get to make the decision.
Mr. Rasconi, you're free to speak. I assume everybody is in agreement that you want to go tomorrow.
I do, I don't want to feel left out, so I feel like I can speak. So,
Okay.
but Your Honor, there's something I do want to point out, the suggestion that the commission needs transcripts and time to process this stuff suggests that the commissioners aren't capable of making a decision after sitting through 8 days of testimony. From at least my view, they've been very attentive. We've asked several questions, several good questions, important questions that seem to suggest that they grasp exactly what we were trying to get across this whole time. And quite frankly, I'm a trial attorney. I take pride in being able to give a closing argument after we're done with the evidence and not having to wait for a jury to go back and read transcripts, which they don't do. And if you're not saturated with this information at this point, I wake up in the middle of the night and I think I'm sitting here. Like it's getting to that, we've been inundated with this stuff. I don't think anybody's at a disadvantage. It's relatively straightforward. Present the evidence, argue the evidence, commission makes a decision.
Okay, thank you. And I think we've heard from Ms. Bourgeois. Can we hear from him on this? No, we haven't. So you can make a closing argument tomorrow. What's that?
I would think my position on this issue is quite clear.
Yeah, I think so. I think you're right. So
Never heard of
if to address your concern, if we do closing arguments tomorrow, then there's going to be a briefing schedule, so you folks can get, if you want, you can put a brief in about what your view is that the entire commission will consider, and you can, write out whatever you want. And in the commission, and my fellow commissioners, upon reading a brief, if they have any questions, I'm sure they'll refer them to you, either post-brief or pre-brief. So, the commissioners have been heavily involved in this case. And in fact, it's my belief that a majority of the commissioners will be listening in on Friday if we do the arguments then. And so we're going to do the arguments tomorrow, assuming we get to them. And that's, we still have at least one major witness to go that we're going to go today with, several hours. And then tomorrow, we have basically the morning up until about 2 or 3 o'clock before I would, and then I want to have time to do, the closings.
So, and again, with respect to tomorrow, we are going to try and you made it possible for me to knock Secretary Bennett off of the list yesterday. I'm still going to explore reducing it tomorrow in order to make it possible for us to do this.
Well, if the parties, and I don't mean to intimate you're under any pressure or I'm rushing you, but if the parties want to finish it tomorrow, the ball is in your court. We'll be able to finish it tomorrow. Ms. Pruitt, what do you have to say?
Just a couple of things. Want to preserve our objection to doing the closing arguments tomorrow.
Okay.
We would ask that our motion to the commission be considered by the commission. And we would like to preserve our, based on that decision by the commission, preserve our opportunity to provide our closing arguments to the full commission. So we're happy to do it twice if that comes to it, but we would like the commission to decide on our motion in accordance with the regulation.
Well, what I'll do, in fairness to you, we'll do the closing arguments tomorrow, and I'll refer your motion to them. And if the commission wants to hear anything further, then the commission will contact the parties and we can take it from there. Okay, I'm assuming they won't, but what do I know? They can certainly decide to do that. But I agree with Attorney Wasconi, every single trial and hearing I ever did, and it's in the thousands, case over, immediately you go into closing arguments. I've never had a delay of a week, much a day, or even 3 months.
The difference in the way that the
Sure.
commission conducts adjudicatory closing arguments is it's more like an appellate argument, so that the commissioners are asking questions. And they do that based on having reviewed the transcripts, reviewed the briefs, reviewed the exhibits. So this is a far departure from the norm.
The norm,
I'm not sure that's right.
the norm has been all over the lot since 1978.
In my experience, I've done 2 or 3 hearings. We did the hearings right after the evidence. That was my experience with the commission. But your rights are saved, so I will refer it to the commission, and if they want to have a second round of closing arguments, which I suspect they won't, they'll let us all know. But having said that, we'll do closings tomorrow, about 15 minutes per party. And if you run a little over, especially the petitioner, because you're addressing 4 separate parties, not one, I'm going to take that into consideration and allow you additional time. And also, if you want to argue one aspect, Ms. Pruitt, and then turn it over to Mr. McDonald and then Ms. Moran to
She
argue
will be
it.
here tomorrow.
What's that?
She will not be here tomorrow.
Okay, well, I'm sorry. So you won't be here tomorrow, but I'm confident that Mr. McDonald and yourself can cover that. So, having said that, it is now 10:01. I say, let's take the lunch break. We'll be back at what's that? Oh, I'm sorry. I apologize. Mr. Bourgeois, I apologize.
Before the lunch break, sir, I kind of got lost in the trample about the Burke report that you said you were going to read during the lunch break. And I did have 2 very brief points that I wanted to make on that issue before you read it.
Sure.
The first point I want to make is that there is a false equivalency between the Attorney General letter and the Burke report. The Attorney General has a statutory and a constitutional defined position to determine whether laws have been violated and to prosecute those violations. On the other hand, Kevin Burke was just somebody who was politically appointed to do a report in a very contentious and politicized environment. The second point I want to make is that the question I'd ask you to consider is not whether that document should be simply admitted and added to the pile, but rather, is it fair that the document should go in without him being cross-examined? Isn't he essentially an expert witness making opinions that have never been tested by cross-examination? I ask you to question whether that's fair to the respondents.
Okay, well, as I said, let me read the document over the lunch and then we can revisit that, okay?
Thank you.
Okay, so thank you. So do you want to do it, come back at 10 to 2 or 2 o'clock? What do the parties wish?
2
What's that?
o'clock, if that's all right?
2 o'clock?
Thank
Okay, 2 o'clock, and then we'll go straight through and hopefully finish the witness this afternoon. Yeah, I read the report. You know, I understand the concerns of the respondents. I also understand the report was prepared, addressing a somewhat different issue, albeit related to the one that we have before us. But given what I've been doing, I'm going to, over your objection, mark it as an exhibit. So
52?
That's correct. No, I'm sorry. Yes, 52.
okay, is there anything else to be addressed? I take it not. Okay, Ms. Kiley?
Mr. Early, would you please take the stand? Call Joseph Early, the respondent.
Okay, thank you. Sir, can you raise your right hand? You swear to tell the truth, the whole truth, so help you God?
I do.
Okay, thank you. Oh, thank you.
Allow me to introduce myself. Tom Kiley. How long have you known me, Mr. Early?
Long time, back when I was in private practice, but I met you before that in the Attorney General's office when I worked in the trial division, and you were the former first assistant, came in to visit Billy Mitchell.
When were you in the Attorney General's office?
1988 through 1990.
Are you currently employed?
I am.
How are you currently employed?
I'm currently the Middle District District Attorney, also known as the Worcester County District Attorney.
When did you take that office?
I was elected in November 2006. I took office, I think, January 3rd, 4th, or 5th of 2007.
Have you been reelected since then?
I have.
When was the last time you were elected?
3.5 years ago.
And what were you elected after the publication of stories involving what I've called the situation in this case?
I'm gonna object.
He can have it. Not particularly relevant, I agree, but
If I may be heard,
Sure.
the situation is not defined. Is he talking about the arrest report? Is he talking about the arrest? Is he talking about what happened in the district court? I don't know what he means when he says the situation. That's all.
well, I'm assuming he means why we're here today, the situation that started in October 2017.
I am aware of the objection to my use of the word situation. I could choose many. Are you aware of that, strike that, you're aware of publicity surrounding your handling of the matter involving the young lady?
Yes, I am.
Were you elected after that?
I was.
Are you running again this year?
I am.
You took your position as district attorney in 2007, you said?
Yes,
You succeeded District Attorney Conti.
I did.
Were there policies in place when you took over for District Attorney Conti?
Absolutely.
Have you adopted policies since then?
I have.
were there policies that continued in the Conti era? Can we call it the early era?
Sure. Yes, there were policies that were in place and that were continued. It's not reinventing the wheel. I adopted a lot of the policies that were in place.
Were there policies in place when you took over from District Attorney Conti that related to probable cause statements in the district court?
Yes,
Were there policies in place when you took over relating to public records?
yes.
Were there efforts made were those policies continued?
We changed them. Some aspects of them were continued, but I put an emphasis on some other things and made some changes.
What matters did you emphasize?
With regards to defendants' right to a fair trial and our speaking and releasing information to the press and to the public, I ran on a theme of transparency. And some of the members of the press, some people said, well, you're not being transparent. So I decided to explain to them our duties and what we were required to do under our rules of professional conduct, specifically with regards to rules 3.6 and 3.8.
I have exhibit 40 for the witness, please.
Thank you.
Thank you, Judge.
What is exhibit 40?
It's an email from Chris Hodgins to Tim Connolly and myself, several other people in the office regarding a media day presentation.
Did that media day presentation occur?
It did.
And what was a media day? And what did you mean by media day?
Media day was, we set up a bunch of speakers for the day to explain to the press what their roles were within the office. Specifically, we spoke to grand jury. We spoke to the open meeting law, which we then had. We spoke to the district and superior court cases. We spoke to public records and rules of conduct, 911 calls, Corey, and what prosecutors can say to the public. And we also talked about the juvenile court and the rationale for why it is closed court to the public.
What were the rules of court that were discussed at that meeting?
We discussed 3.6 and 3.
I'm sorry, I misspoke, I misread. What were the rules of conduct that were discussed at that meeting?
We discussed my rules of professional conduct, 3.6 and 3.8, and what we could and couldn't do. For example, I didn't want to make it a policy handing out booking photos. I did not want to hand out arrest reports. I did not want to get into things that I felt that could negatively affect me with regards to pretrial publicity, but I wanted to explain that to the press and to the public, as to why we were doing what we were doing for transparency's sake. And at the same time, let people know that I hadn't broken any vow that I had taken when I ran to office. We could be more transparent, but still, there were protections that were in place, and that also went to the grand jury in not releasing grand jury minutes to anyone but the defendant.
That policy continue in effect throughout your tenure as district attorney?
It has.
Was it?
Sorry to interrupt, Joe. I'm sorry, but can we have a date on this
Sure.
presentation? I just didn't have the date. I'm sorry.
Thank you. Exhibit 40, the start date is May 23rd, 2008. And if I can direct your attention, Mr. Early, down to bottom part of the first page of Exhibit 40, You see a memo there dated May 13th of 2008,
I
correct?
do.
The last page of Exhibit 40 reflects part of a presentation on public records, does it not?
Yes, special obligations of prosecutors.
With respect to public, the issue, the public record request line, is that presentation made by Chris Hodgins?
Yes.
And has Chris Hodgins made other presentations with respect to the policies of your office with respect to release of documents?
Yes, he has.
Has Chris Hodgins also made presentations respecting what it is that should go into applications for criminal complaints?
Yes, he has.
I want to direct your attention to Exhibit 43, admitted. We're done with 40.
Thank you.
Thank you.
There's not going to be a quiz on all those pages.
Thank you for that.
I want to direct your attention to the first page of the admitted Exhibit 43. Would you please identify what this document is?
This document is dated February 20th, 2017. It is,
Let me stop you there. Would you please look at the first paragraph of the letter?
yes,
Please read the first 2 lines of that paragraph.
please see the enclosed documents in response to your February 2nd, 2018 request made with the District Attorney's Office for policies, correspondence, statistics, and documents regarding impounding and or redacting police reports.
And is this letter addressed to somebody?
Yes, it is.
And is it to Mr. Patricia?
It is.
And this is a response to a public record request, correct?
Yes, it is.
Did this, is it your memory that this communication occurred in 2018?
Yes, it is. Yeah, there's a typo at the top. It's February 2nd to 2018, not February 20th. And so it should say February 20th of 2018 as well.
I want to direct your attention to the second sheet in the package.
Yes,
What does that page and the next several pages refer to?
rules of professional conduct, Rule 3.8, special responsibilities of a prosecutor.
Does the second sheet refer to rules of professional conduct, Rule 3.6, trial publicity?
Yes,
And there are several pages relating to the rules of professional conduct, correct?
yes, there are.
And had adherence with the policies of the rules of underlying rule, your pretrial publicity existed throughout your tenure as district attorney.
Yes,
I want to direct your attention to the bottom of the page. Is 003862. About 5-6 sheets in. They start and run
Yes.
sequentially.
I got it.
What is that page?
Special rules of prosecutors, rules of Supreme Judicial Court.
And at the bottom of the page, there's a citation to 2 cases, is there not?
Yes, there are.
What are those 2 cases?
Newspapers of New England Inc. versus Clerk Magistrate of the Ware District Court, and quoting Gannett Company versus Di Pasquale.
Well, who wrote that? The materials on page 003862.
Chris Hodgins.
And there is a reference there, is there not, to the constitutional obligation to limit pretrial publicity?
Yes, there is.
I'm not gonna have you bother to read it. I want you to look at the page opposite it, 3861.
Yes,
Does 3861 deal with a policy of your office?
yes, it does.
Is it a continuation of page 3860?
Yes, it is.
And it is captioned, is it not, statement of facts controlling the flow of information?
Yes,
Does this document relate to police reports?
yes, it does.
Who is the author of this particular page, these 2 pages?
Christopher Hodgins.
And what was the policy of your office in 2000 and, I'm sorry, take that back. At the top of that page, 3860, there's a date, May 13, 2014. You see that?
Yes.
What was the policy of your office in 2014 with respect to the applications for criminal complaints?
That the police were to write a probable cause statement or short statement of facts dealing with the element of the case, rather than attach a full arrest report, police narrative to the with the application for complaint.
And did you sit in on this presentation in 2014?
No, Chris and I discussed it. We talked about doing it. I gave it my blessing, asked him to do it. I wasn't there for the training, no.
Was the policy with respect to the application for criminal complaints one carried forward from the Conti era?
I don't believe they did as much, but I think it was always their preference to get a probable cause statement of facts. Chris was still in the office then. I believe this was the same policy, yes.
Was that policy written in a kind of compendium of policies?
No, I don't believe so. He said, Chris is head of the litigation integrity unit. But a policy book, actually, I think it is. What's that?
Tri-Garrity unit?
Litigation
You said
integrity unit.
litigation and, oh, integrity.
Integrity unit.
Chris Hodgins, you sent through his testimony.
Yes, I did.
He's fulfilled a number of roles over the course of time.
Yes, he has.
One of them is educating the law enforcement community and others as to the policies of the office.
Yes, he writes a monthly newsletter. He does a lot of things with regards to training. Yes.
In 2017, when this situation
Objection.
came to your attention, had you had recent discussions with Mr. Hodgins concerning the disclosure of information pre-trial?
Yes, just the week before, I think that Friday, we had discussed 2 cases.
May I have, I'm done with that exhibit. May I have exhibit 44?
Okay. Thank you. Thank you.
Thank you.
You recognize exhibit 44 to reference the 2 cases that you discussed with Mr. Hodgins.
Yes.
There are 2 separate letters in this document, are there not?
Yes, there are.
You were here when Mr. Hodgins indicated that when he put the dates on letters are the dates he sent them, correct?
Yes.
Did you just tell us that you discussed these matters with Mr. Hodgins the week before?
Yes, I did.
I want to direct your attention to the first of the 2 letters. I want to direct your attention to the second page. And I want to direct your attention to the bottom of the page. Do you see at the bottom of the page a citation to 2 cases?
I do.
Are Are they the same two cases that you just referenced in your testimony?
Yes, they are.
And those two cases are preceded by a sentence that deals with special obligations that prosecutors have to limit pretrial publicity.
Yes.
I would like you to look to the page 4 of the document. So we're down at the bottom,
Yes.
top paragraph. Do you see a citation to two cases?
Yes.
Are they the same two cases?
Yes, they are.
Read the sentence that immediately precedes it.
Disclosure of interview transcripts would also result in premature disclosure of the Commonwealth's case prior to trial.
And there is a reference again to,
Lucas, 371 Mass at 62, Newspapers of New England, Inc. versus Clerk Magistrate, the Ware District Court, Gannett, quoting Gannett Company versus De Pasquale.
and there is a parenthetical again, correct?
Yes.
Government has an affirmative constitutional duty to minimize the effects of prejudicial pretrial publicity, and a citation to the rules yet again, correct?
Yes, there is.
I want you to look at the next paragraph. Read the last two sentences of it to yourself.
Yes.
They repeat what you just read up top, do they not?
Yes, they do.
I want you to turn to the last page of the letter. There is a carryover paragraph, is there not?
Yes, there is.
I want you to read to yourself the last two sentences of that paragraph.
Yes.
Are they identical to what you have read before?
Yes, they are.
So on or about Friday, or the week before October 17th, you were discussing with Mr. Hodgins letters on a case of moment dealing with the release of materials and the requirements that you had, special obligations as a prosecutor to avoid pretrial publicity.
Yes, we were.
And prejudicial pretrial publicity is a problem for a variety of reasons, isn't it?
Yes, it is.
Would you articulate the reasons it is a problem?
Number one of the most fundamental rights that we have is to have a trial free of prejudicial pretrial publicity. It's due process. It's right in the Constitution. The courts have told us time and time again, the case should unfold in the courtroom. It should not unfold in the media prior to trial.
Thank you. You can put that document aside. The week before you learned of the arrest of the young lady in this case, those discussions occurred.
Yes, they did.
When did you first learn of the young lady's arrest?
I believe on the 16th at about 6 in the morning.
I have exhibit 28. While Ms. Duca is getting exhibit 28, how did you learn it for the first time?
By a text message from my senior first assistant, Jeff Travers.
Thank you.
This document admitted 28 is labeled text messages between ADA, Jeffrey Travers, and DA Early, correct?
Yes.
I want to direct your attention to the middle of the page after DA, the letters DA, after it. Do you see a date down below?
Yes.
I'm sorry, that date is down below is 2017, 10/23, correct?
Yes.
And that is an indicator as to when the text message that is below was sent to you, correct?
The date below is,
Please answer my question, Mr.
Sorry.
Earl. This is a yes or no.
could you repeat it?
Objection.
Could you
No,
repeat it?
yeah, why don't you just repeat that?
Strike, I'll rephrase. There are two dates reflected in this document, are there not?
Yes, there are.
The first date is under the second JT
Yes,
document. And it is, what is the date that is there?
October 17th, 2017,
And is there a time provided?
7:51 a.m.
Is this, that text message up at the top reflect when you learned
Yes,
of the matter for the first time?
yes,
And you responded, did you not?
I did.
And how did you respond?
TY,
TY means
thank you.
that was up your entire response.
That was it.
You had a subsequent communication by text with First Assistant District Attorney Travers, correct?
Yes,
And it occurred, did it not, on October 23rd at 11:03 in the morning?
yes, it did.
And October 23rd is the day, is it not, that the case was actually transferred out of the Middle District?
Yes, it is.
There were no other text messages between you and Jeffrey Travers dealing with the situation.
No, they weren't.
Did you learn further of the situation on October 17th?
I did.
What, sequentially, what occurred next?
I was in the office and Jeff walked by me. I think he passed me in the hallway. And he said, there's an arrest report. And where's the effect of the language is bad. It's bad.
Did you make note of that?
Just put mental note.
And what happened next with respect to this matter?
We were very busy that day, as I remember it. I came back to my office later and the copy of the arrest report had been placed on my desk or on my chair in my conference room.
And what, did you look at it?
I did.
And what occurred next?
I skimmed through it quickly and when I got to a line in the report, my head exploded.
Go ahead, explode.
My head exploded.
What?
It was one of the most salacious comments I'd ever seen in an arrest report. It was just, it shouldn't have been in there. It was wrong. I knew that this was going to get leaked to the press. We've been telling departments, don't do this. A short, concise, probable cause statement or a statement of facts. Quotations like that had no business being in an arrest report that was placed in a public file.
Did you act on that head explosion? As soon as you read that,
I did.
what did you do?
I asked Jeff if it was impounded.
And what did you learn?
I learned later that a motion to impound had been filed by the defense attorney. We did not object to the motion, and that the matter had been impounded.
Did you learn whether, at that time, whether the impoundment order was finite in duration?
My belief was that it was limited in time, that it was finite. That was my own belief. I didn't get anything else with regards to that.
You subsequently learned that it had no duration on the document that had been filed by Ms. Colby.
There was no duration on the document, yes.
Did you learn further of the report in the situation from somebody else later, outside of your office later in the day?
Yes.
Objection. I didn't understand the question.
Okay, you want to repeat the question?
I thought he understood it.
Well, it's important that the other side to understand the question. Can you just repeat it for her benefit?
Did you receive a communication with respect to the matter from somebody outside of your office on October 17th?
I did. Chief Justice Paul Dawley of the District Court.
How did that come about?
He called me later in the morning, early afternoon, somewhere in that time frame, or in the afternoon. He gave me a call to talk about the matter, the situation.
Do you recall the conversation?
I do.
Given that it's 4.5 years ago, what do you recall about the conversation?
He told me that the case was going to be transferred. He wasn't sure where yet. We talked about young woman. We talked about substance use disorder, also known as heroin addiction.
Who brought that up?
I think he did. What the family was going through, he mentioned they'd been going through a horrendous time, hard time with regards to this for a period of time.
Did he ask you to do anything?
No,
Did he ever ask you to do anything with respect to the report?
no,
Secret, is that what you call the conversation?
pretty much, we were talking about it. He thought the language was horrendous within the report. He expressed that, and we've talked, we went back and forth about opioid addiction, how it's being dealt with now, and he said, I'll get back to you. I don't know where this is going, but it's gonna be going somewhere. Words to that effect, given that it was, yes, 4.5 years ago.
Did you communicate with anybody else outside of your office? Strike that. Did you communicate on this matter with anybody within your office on October 17th?
Yes, I believe I may have.
Do you know who?
Yeah, I think it was my first assistants, Jane Sullivan and Don Zenos.
You have multiple first assistants.
I do.
Times have changed.
They have. It's not statutory anymore.
Jeffrey Travers was the senior first assistant.
Yes.
Right? When you looked at Exhibit 28, you and the initial email from senior first assistant Travers, the first line opens per Ed, right?
Yes.
Who's Ed?
Ed Carcasinas, he's first assistant. He's also head of the domestic violence division within the office. And at the time,
Do you recall having any conversation with him on that day about the matter?
no,
Was there any discussion about what the office should be doing with respect to the matter internally on the 17th?
I mentioned, I believe in that conversation with Jeff, I spoke about prejudicial pretrial publicity.
Did you talk with anybody else outside the office on October 17th?
I did. Colonel Rick McKeon.
How did that communication come about?
I called him.
Why did you call him?
Well, felt it necessary to call him. I got a call, there'd been an arrest. I got a call from a chief justice. The language in the report was put into a public file. And I also wanted to see if the colonel and I were on the same page with regards to opioids. And if he didn't know about the arrest, I thought he should know about it.
Why should he know about it?
Well, situational awareness of things, you want to know. I've used the expression before, when your coat is on fire. If something's going to be put out, broadcast out, you don't like to get caught off guard when you're in a position of, I can speak for myself as the DA, it's in my communication seat. If there's an arrest that's noteworthy, if there's something, I want to know about it before I get questioned about it. So please bring those things to my attention.
In that initial, the call that you initiated, did you ask Superintendent Colonel McKeon to do anything?
No,
Were you and Colonel McKeon on the same page?
we were. I was pleased to see that we were on the same page when it came to the new normal in policing, when it came to the opioid crisis.
Was there a discussion at that point about supervision?
It was.
Brought it up.
Colonel McKeon did.
Um, Again, recognizing it's a long time ago, what do you recall about how it came up?
I said to the colonel, did you hear about that arrest over the weekend? Did you hear about the arrest report? And he said, no, I did not. What arrest? And I said, Judge Bebo's daughter had gotten arrested and the report is pretty graphic. And he said to me, again, it is 4.5 years ago, he said to me,
Stop for a second. Did you describe the graphic language? Did you provide him with the graphic language at that time that made your head explode?
I did.
And is the conversation that you're recounting now based upon, follow that disclosure, if you will?
Yes, after I told him the line that bothered me within the police report, he said to me, where are the supervisors? That's the supervisor's job. I've told them 1,000,000 times, I don't want language like that going into police reports. Enough people dislike the state police already. We don't need to be adding to that list. As best I remember.
You've sat through these proceedings, correct?
Yes, every day.
You absented yourself yesterday during Colonel McKeon's testimony, didn't you?
Yes, I did.
Why?
I didn't want anyone to think, first of all, Colonel McKeon and I have not talked about our testimony in this case, what was going to be stated, what was going to be said. We did not sit down together and talk about the testimony in any way, shape, or form. And I didn't want anyone thinking that we have. I decided to take myself out of this room yesterday to ensure that I didn't want to hear his testimony. I knew what I was going to testify to. Pretty good idea what he was going to testify to, but in no way, shape, or form did I want anyone to think I was coached by what he said or that we had gotten together to talk about our testimony.
Coordinate your testimony in 2017 at the time of inquiries by other bodies. You
I'm sorry.
understand that question? The situation unfolded in 2017, correct?
Yes.
And at some point, you and the colonel were asked questions. You were asked questions about it, correct?
Yes, I was.
Some of the inquiries that came in 2018.
Yes.
Did you and the colonel communicate about what your testimony was going to be after those when the initial inquiries were made?
No, never.
After the story that appeared in the media, did the two of you converse about how you would testify?
Never. No.
Did any of the individuals try that? Do you recall any other conversations with people in government or outside of government that you can firmly place on October 17th, 2017?
Spoke to you.
Can you firmly place that on October 17th?
I believe I can. Yes.
How can you place that on October 17th?
We had the situation with regards to the arrest. You've been my attorney for years. We had a former employee who had gotten arrested. She had gotten arrested and there was language within the report regarding heroin use. I knew she was vulnerable. I knew she was at risk. I knew that there were statements that I believed would get leaked to the media. And I called you to see to get advice as to how I should handle it and how this played into my rules of professional conduct 3.6 and 3.8, and what my role, what my duties were with regards to the DA, these statements, and the right to a fair trial, free of pretrial publicity. And my role, and as I have before, my role within the criminal justice system as chief law enforcement officer in the county.
Do you have any records that nail down the date as October 17th?
No,
If it occurred on October 18th, that would also be possible.
yeah, it's possible, but I believe I talked to you, and I can't put it when in relation to the 17th. I wasn't sure if it was before. It wasn't before I don't believe it was before. I can't say specifically whether it was before the call of Chief Justice Dawley or my call to Colonel McKeon, but it did. I believe it happened on the 17th.
After the initial calls with those two gentlemen.
It would have been late in the day. It would have been late in the day. That's typically when I try not to bother you during the day, but I usually.
Just, you're under oath.
Yeah. I do lean on you for a lot, and I respect your counsel because, and it goes back to when you were first assistant with Attorney General Francis Bellotti.
I'd
So
like to make an objection. I'm not sure if Attorney Kiley is acting as counsel or a witness at this time. I'm
Okay.
not sure what I'm.
Okay, that's
seeing.
overruled. Thank you.
Did you talk with anybody else outside of government about this matter on or about October 17th?
I did, my wife.
There's a spousal privilege there. Are you going to waive that?
No, I'm not waiving that. No, that's not relevant to these proceedings. I'm not waiving that.
I'm not sure it's waivable.
I don't want to get him in trouble either. Are you prepared to talk about the advice that you received from me?
Yes,
First, as a general proposition, what were the subjects on which you had been receiving advice from me as of and prior to 2017?
there were a lot. Campaign.
No, I'll just, at this part, I just want to, because there is an attorney-client privilege,
There is.
right? And by you asking these type of questions, it kind of opens the door
I
to
understand.
her now going, to all sorts of prior, advice you might have given him, so,
We're only going to do subjects on this matter.
okay, but theoretically, that kind of, they may,
Theoretically, they can.
what's that?
Theoretically, they can.
Well, I just want to make sure we're all on the same wavelength here.
Well, there's a waiver.
Can we have a 5-minute break, Judge?
Sure. My 5-minute break to, okay, we'll take a short break, okay?
I mean literally 5 minutes, because I don't want to interrupt this.
Okay, I'm not gonna leave, I'll just stay here,
I could
okay,
use
5
some
minutes,
extra myself.
okay.
What subjects, what kinds of subjects had we discussed? Had I represented you on or advised you on prior to October 2017?
Campaigns, rules, compliance matters with campaigns, rules of professional conduct.
Those were compliance matters?
Yes,
On October 17th or 18th or whatever it was, were you seeking advice with respect to compliance matters?
yes,
Thank you. Are you, with respect to the communication between us on October 17 or 18, 2017, are you aware that those communications were privileged?
yes,
Are you willing to waive the privilege with respect to that advice?
yes, I am.
What was the substance of the advice? Do you recall the substance of the advice that you received?
I do.
Can you please summarize it?
Yeah. My questions were directed, my role, my responsibilities. And we discussed how, as the chief law enforcement officer in Worcester County, that my authority is superseded by that of the Attorney General. In turn, the role she has over me, my authority supersedes that of the police. And it supersedes that of the police when it comes to evidence that's going to be presented. And I decide when and where evidence will be presented and whether or not a case will go to trial. Also, we discussed my obligations as a prosecutor. Specifically, my rules of professional conduct 3.6 and 3.8 is they deal with pretrial publicity. In my obligations as the district attorney to take reasonable steps to ensure that the police are consistent with their public statements as I am with mine. And that goes to statements, that goes to police reports, and we discussed that. And I was particularly worried here because of the statements. Like I said, the young woman was at risk, she was vulnerable. I believe this was going to be leaked. And these type of statements, now, addiction compromises judgment. And these type of statements, I was worried would crucify her, kill her. They get out, they're in a public file, they get out. And heighten her public condemnation, and also further stigmatize someone who's going through substance use disorder, especially with what I was learning with the opioid crisis.
You testify you got advice about the opioid crisis from me?
No, that was me. I knew that. The opioid crisis was mine.
But for the discussion of the opioid crisis, was the discussion of the rules of professional conduct, the powers of the district attorney, was that discussed in the first conversation that occurred between us?
Yes.
Was there further advice rendered at all during that week?
Yeah, as it got amplified, as it played out a little bit.
What way?
I called you about impoundment, Well, I wanted your
Why me?
I wanted your legal opinion. I wanted your legal opinion as to what I could, what I should, what my duties were as a district attorney. Again, you've been the first assistant attorney general for Francis Bellotti.
Well,
And I relied on your advice. There's a lot of landmines in this business, and I relied on your advice.
was there any discussion? Were you advised with respect to impoundment-related matters?
Yeah, and I was surprised you knew so much about impoundment. But we talked about impoundment and how much it had changed over the last 30 years. And that impoundment was finite in its duration. And we talked some more, and you told me how redaction is actually a preferred method right now over impoundment.
Did you take any action based upon the advice?
I had discussions. I hadn't taken action yet. But I was looking at, I knew I had to do something. I was looking at redaction, the possibility of redaction, what we needed to do with regards to those statements and preserving our rights to fair trial, free pretrial publicity.
Did all of that occur before your next communication with Colonel McKeon?
It occurred before, yes, it did. Well, there may have been one or two calls here, but it occurred before the call I got from him on Friday. It did.
So you sat
Yeah.
through the hearings. You know that based upon the evidence here, that the first communication with Colonel McKeon was on 17th.
Yes.
At least that's what the documents show.
Yes.
There was a point when, you know, not from listening to the colonel, you know that there was an order that the colonel issued for a request with respect to the report itself.
Yes.
And there was a communication, was there not, in which you initiated contact with the colonel and asked him and discussed with him whether the ship had sailed?
Objection.
Much objection?
Meeting.
Okay, well, so ruled.
We had a discussion. I said to him, where's the effect of, are you doing anything about it? And he said, what do you mean? Again, words to that effect. And I said, the supervisors. What do you mean? Well, you said they didn't do their job. Are you doing anything about them not doing their job? Are you asking them to do their jobs? And he said something to the effect of that ship has sailed, something like that. And I said to him, well, I don't think it has. And I'm going to do something. I'm going to file something. And I told him that I had talked to you. And I also suggested if he had any questions that he should talk to you. I did that from time to time. He didn't bother you as much as I did. I don't know how much he does call you or if he called you at all. I knew you two had talked, but I told him I did not think it was too late to do something.
And did you at some point indicate you were going to file a motion to redact?
I did.
And did that precede the order that the colonel issued?
It did.
How do you know that?
Because I had talked to you. And
How do you know it preceded his order?
it happened during the week. And the next time there was another conversation after that, I heard from him. And that's when he told me that he was sending down another report. That was the chronology of it.
When did you learn that he was going to, that another report had been drafted?
It was the morning, I believe, of the 19th, or a little later in the morning. He told me another report was coming down.
Did you do anything as a result of receiving that information?
I said, good for you, Rick. I thought you had to do something. And I had also suggested, you could use this as a teaching moment, or if you want, Chris Hodgins can come down and Chris can do his training that he did for the chiefs of police. He could do it for the state police.
That's something you suggested to the colonel.
That was my suggestion to him, yes.
Did you take any action other than communicating with the colonel as a result of learning that another report of some kind, another document was going to be, in your words, coming down?
I told Jeff that another document was coming down, and I also went upstairs to see Judge Despotopoulos.
So let's focus first on Jeff.
Yeah.
When you talked with Senior First Assistant Travers, had you seen the document?
I had not, no.
Did you know what was going to be in the document?
I did not know what was going to be in the document, no.
You just told the court that you were gone upstairs to talk to Judge Despotopoulos, correct?
Yes.
What was the purpose of your going upstairs to see Judge Despotopoulos?
I went up to see him to get dates to go visit a program in Essex County. It's a unique program specific to the opioid crisis that I was trying to bring to Worcester County. And it's for the hardest of hard cases, but it's a lifesaver. It's a prison program that's separate and distinct from prison population. It's a dormitory type setting where people who are sent to jail get services from the time they get up in the morning to the time they go to bed dealing with the opioid crisis. Essex County had a 25-bed dormitory for men, a 25-bed dormitory for women. I had taken some state legislators, senators, reps. I had taken the sheriff and his staff out to see the program that Sheriff Coppinger was running in Essex County. Not everyone could go on the first trip, and I had trouble getting dates, coordinating dates with 30 people. Judge Despotopoulos was one of the people that I needed to get some dates from. I didn't want to let this slip or go on too long. I needed dates from Judge Despotopoulos that he could go, he'd be able to go out and visit the program, because they said they do 2 trainings for us.
You have the report, or did you have the report from, the new report from State Police Headquarters at that time?
No, I did not.
You engaged in a conversation with Judge Despotopoulos, correct?
We did.
And at some point, did Brendan Keenan arrive?
Brendan Keenan arrived, yes.
And the conversation between you and the judge prior to Mr. Keenan's arrival, was it focused on the program in Essex?
Yes, that's the only thing we talked about.
You knew at the time that another document was going to be received.
I did know that, yes.
And I think you told us that on direct here, that you told First Assistant Travers that something was going to be coming, correct?
I told him that there was a new report, I believe was my language, something along those lines was coming down, and that he should be on the lookout for it.
Did you give him any direction what to do with it?
No, I did not.
Did you initiate a discussion with Judge Despotopoulos about the report?
No, I did not.
Did you ever ask the judge or Brendan Keenan to take an affirmative action to swap the report, one document for the other?
Absolutely not.
Did you understand that what was going to be coming was a redacted document?
I assumed that it would be some type of redaction dealing with what the supervisors were supposed to do, that the colonel was unhappy that they had not done.
Did you see whatever the change report was while you were in the company of Judge Despotopoulos and acting clerk Keenan?
No, I did not.
Was there a discussion? Did you ask what could be done with the report?
Clerk Keenan brought it up, and he said there was a new report was coming down or was here. And I said, yes, I was aware of that a new report was coming down. And I asked a lot of questions. What will happen with this? Does this take the place a new report? Does it go in with the original report? Basically, the clerk, it's a trial court function. I want to know what they were going to do with the report.
Were you aware in that conversation that Senior First Assistant Travers had talked to Mr. Keenan?
I wasn't. I thought his timing was off a little bit. I thought Jeff was downstairs waiting for the document. So I've been thinking about this lie. I thought he was still downstairs. I did not know that he had talked to Clerk Keenan with regards to the document.
Had you left the matter in Jeff Travers' hands?
What I said to was be on the lookout. There's a document coming down. Be on the lookout, and that's how it was left.
And the way the meeting with Judge Despotopoulos, in which Brendan Keenan participated, how did that end?
Judge Despotopoulos said to him something to the effect of, another document coming down. He asked Clerk Keenan a question, what would be happening with that? And he said, well, this would not take the place of the original document. This would go in addition to the document. They would both, my understanding was they would both be in the file.
Is that your understanding?
And I said something to the effect of, when he said it would not take the place of the original, and I said something to the effect of, I said, no, it wouldn't. He said, no, it would go in with the additional as an addendum or an additional report.
Do you have any intention as you went upstairs to be discussing the disposition of the report?
No, if it came up, I was gonna discuss it. I went up to talk about getting that date for Essex. I knew, though Chief Justice Dolly had called me, I knew they could be and would be a little bit upset, and I was prepared to discuss it if it came up.
Who's they who would be a little bit upset?
Judges.
So did somebody say to you, did anybody among the judges ask you to do anything at all?
No, they did not.
So was your visit to Judge Despotopoulos motivated by a desire to placate the judges?
I was checking the temperature, if you will. I was just curious. I don't think Judge Despotopoulos knew that I had talked to Judge Dolly. But and at the same point, after I had talked to Rick McKeon, I knew this was not what he wanted, shaming, humiliating, or embarrassing people. And if it came up, let's just say that's not what Rick McKeon is about. I think he was a little bit upset about it. I want to communicate, have a little bit of communication.
Had you discussed in 2017, the work of your office dealing with substance abuse disorder?
Yes,
Had you discussed your work with respect to the opioid task force?
Yes.
Objection. Discuss with whom
Okay, that's overruled.
and where?
Okay, that's overruled.
yes,
Yes.
yes, I did.
Had you discussed it with Colonel McKeon?
We hadn't really spoken prior to that about the opioid crisis, no.
When you first contacted Colonel McKeon, you wanted to know whether you were on the same book and page, correct?
Yeah, I did.
Were you aware of his service on the commission in 2014?
No, I had no idea how heavily involved he was with the opioid crisis as well, and I was relieved to hear it.
You know, Ms. Pruitt has said forever that this case isn't about the opioid crisis, correct?
Yes,
Is this case about the opioid crisis in your mind?
absolutely. Absolutely.
In what way?
In many ways. First of all, half of the country believes that this is some type of moral failing or a character flaw. The smartest medical minds in the country have told us that this is a very complex disease of the brain, and we've got to treat it as such. And this is a stigma that this is a moral failing character flaw on the part of the people who have this substance use disorder. That they can just give it up anytime they want, that they can quit. But these medical minds have told us this is a very complex disease of the brain that actually rewires the brain. It controls the part of the brain that deals with reward receptors. And I had spoken about this. I gave 225 talks before this arrest with regards to opioids and stigmatization of people, and how these people aren't junkies, they're not losers, they're not addicts. Excuse me. They're our sons, they're our daughters, they're our brothers and sisters, our nieces and nephews, our mothers and fathers, and our grandparents. These are people who are suffering from a very complex disease of the brain.
See all of this?
I do.
Have you given me everything that's in my hands?
Yeah, I have.
I'm not gonna ask about. Did you create an opioid task force?
I did. We did. There's no I in team. We did. With a lot of people in the private sector, public sector, faith-based groups, law enforcement, the medical community, the recovery community. We started an opioid task force in 2014, which is now over 700 strong.
And the speeches that you discussed were delivered in part because of your role in the opioid task force?
Yeah, law enforcement changed.
And the focus on law enforcement change had started before 2014.
It had, I was learning on the fly. I represented a lot of people who were addicted to heroin when I was in private practice. And the old thing, I heard Colonel Osteen talk about how there used to be a crime knowingly being present where heroin is kept, and so much had changed. So it really changed in law enforcement. And around 2011, 2012, we started seeing exponentially more people die because of substance use disorder and overdose deaths. It was doubling every year. In 2017, we lost 70,000 people to the opioid crisis. And it was predominantly in the United States.
Who's we in that instance? Country?
Yeah. 5% of the world's population, yet we were using 80% of the world's prescribed opioids.
You learned much of that information as time went on, didn't you?
I did. Started going to the Prescription Drug Abuse and Heroin Summit in Atlanta. My first year was 2015, and I was just amazed. There were 3,000 people in the room, all had the same story. And we were hearing from the experts, and the biggest problem that everyone had was a stigma. And everyone was stepping out of their silos, sharing information, how we fight the opioid crisis.
So I lied. Not the first time, it won't be the last. I am going to ask you about a document.
Yep.
May I have the one page of admitted exhibit 7? Bodies all have copies, you know, of a single page.
Yes.
What is the document that you have in your hand symbolize?
This document is part of our anti-stigma campaign to make people aware that these weren't junkies or addicts. Don't shame people. It's not junkie. It's mother, father, brother, sister, niece, nephew, cousin, and ask, how can I help? We had our interns, they actually came up with this as part of we had an intern program. And ever since, I want to say 2015, we'd had them work on a specific part of the opioid crisis. This dealt with our anti-stigma campaign.
Did your able staff come up with the lettering on the document, the reds and the blacks?
I think that was the interns that came up with us, and they brought it to us, and I was very impressed with it, and I wanted to use it.
And it reads the red letters, reading downward, read.
And stigma.
Have you seen that poster in other law enforcement offices?
Something similar to it, yes.
Where'd you see it? Where did you see it in relation to this case?
The Attorney General's office, when I went in to be interviewed about this matter, had a big thing in their office similar to that, dealing with stigma, dealing with the opioid crisis, dealing about empathy and compassion.
With the colors?
I don't know if the colors were the same. I really, I don't know that I could describe that in greater detail than that.
Can I have disputed exhibit 16?
Here you go.
Thanks, Judge.
Is disputed exhibit 16 the text that you use in delivering one of your, what did you say, 275 speeches?
225 speeches.
225 speeches. And that is the date that is on that indicative of when you delivered it?
Yes.
And does that document reflect what you knew in 2016 with respect to what was going on in the world of concern to families and those suffering from substance use disorder?
Yes.
Is there a reference in it to the programs and stigmatization that you were dealing with at the time?
Yes.
What was your message in 2016?
That this was a tragedy, that we had to fight this, we had to fight it together. We had to remove stigma. We had to start remembering that these aren't grim numbers on a spreadsheet. There are sons, daughters, brothers, sisters, family, friends, relatives that people had to speak up, that we had to use empathy and compassion when it came to this fight, and that stigma would close the doors to treatment. Stigma would shame people and prevent them from getting treatment. And that if we continued to do this and didn't get better at it, we're just gonna lose more and more people. We had law enforcement was making changes. They were talking about the use of Narcan.
Do you carry that all the time?
I carry Narcan. I don't want to witness an overdose and not have it in my pocket. I talked about the different things that were going on throughout the county. I'm working with all our partners. You know, law enforcement was changing. We had to adapt with the times. Trainings had to change. The way we looked at people had to change. We had to do a better job than what we were doing.
What author exhibit 16?
Thank you.
Did I offer the one page? I'm gonna offer the one page that came from disputed exhibit 7.
Are you offering disputed?
I just did offer 16 as well. Oh, I'm sorry, do you have 17 there? I will be offering that as well.
I have I have disputed document 16, which is what the witness was just relying to.
I do move that in, yes.
We object to the respondent's self-serving statement on a matter that's not before the commission. Again, this is not about people in crisis, and this is a speech.
Okay, so, okay, this is, can you hand that to the court reporter? And that's exhibit,
53.
And I'm gonna move what was previously shown the witnesses is, it comes from disputed 7.
this is what he had already testified to. I take it you have the same, I take it you have the same objection?
Yes.
Okay, thank you. You hand that, that's admitted.
I have disputed exhibit 17. Handing you a document, is it reflect one of the speeches you gave in connection with the opioid task force? You numbered at 225.
Yes,
What's the date on it?
October 11th, 2017.
It was the week before the Bebo matter came to your attention.
Yes, it is.
So in the week prior to the Bebo matter coming to your attention,
Yes,
you would deliver a speech dealing with the matters involving the opioid task force, correct?
yes,
You then discussed with Assistant District Attorney Chris Hodgins your special duties as a prosecutor, correct?
yes,
And when you read this the report and on October 17th and your head exploded, it related to the opioid crisis, did it not?
it did.
Was it a relevant circumstance in everything you did, correct?
Absolutely.
I don't think there's anything else.
You moving this into
I
evidence?
am, but I want to check on anything else when you speak. I'm gonna move it in as it is, yes.
I take it the petition has the same objection?
Yes.
Okay, thank you. That's admitted. Sir, can you just give that to the court, please?
Exhibit 55.
Okay,
I'm done.
you're done, very good. Okay, Ms. Rusconi, it's,
Good afternoon, District Attorney Early.
Good afternoon.
District Attorney Early, I'm sure as you know by now, I'm Mike Rusconi. I represent retired Colonel McKeon.
Yes,
can you hold on 1 second, please? What the missing questions that someone wanted me to ask you? Okay, so these are the questions. You know what I'm gonna, because once again, I just got a series of questions that one of the commissioners have asked me to ask. So Mr. Kiley, I'm gonna ask you to stand up there. So I'm guessing that you may have some follow-up questions to these. Okay, these are from one of my fellow commissioners. Questions from Mr. Early. When did you learn of the arrest?
I learned of the arrest on the morning of the 17th.
Okay. What was the first thing you did after learning of the arrest?
I texted Jeff Travers, TY, thank you.
Okay. What options did you consider once you read the arrest report?
My first reaction to Jeff was, like I said, my head exploded. Jeff, is this impounded?
Okay, that was okay. Who first suggested replacing the arrest report?
No one ever suggested replacing the arrest report.
Okay, how many OUI police reports did you review in 2017?
I don't know. I don't remember. It wouldn't have been many.
Okay, and what did you ask Judge Despotopoulos to do concerning the police report, and what did the judge say?
I didn't ask him to do anything with regards to the police report. I directed some questions towards Clerk Keenan, as Judge Despotopoulos and I were both asking Clerk Keenan questions. We're both getting smarter on the issue.
Okay. Madam Court Reporter, are you having any problem? Because he's looking at me.
No, I can hear him.
You
Thank
can hear him? Okay, thank you. And last, why did you tell Mr. Travis to go to the clerk?
Oh, I said, Jeff, after I came back down from Judge Despotopoulos and Clerk Keenan, I said, Jeff, go down to the clerk's office, see what's going on with this. Again, it was a trial court function. At that point, I thought both of them were going in, and I was just sending him down to verify what was going on, what was happening.
Okay.
Jeff, go down and see what's going on with this.
You told Jeff to do that at some point, correct?
Yes.
You know that from the testimony you've heard that you had already talked to Brendan, correct?
Objection.
You knew that when you were talking to Brendan Keenan.
Yeah, that's overruled.
Yes. He mentioned that.
But that was your understanding.
Caught me by surprise. Yeah.
Thank you.
Okay, thank you. Okay, Mr. Rusconi, thank you very much. Sorry to have interrupted you.
No problem, no
Okay.
problem at all. Good afternoon again, Mr. Attorney Early. I'm not gonna repeat myself with respect to what I said earlier, but fair to say, prior to this, we've never met.
We've never met.
I practiced in your county before, but we've never actually come across each other.
No, we haven't.
You referenced a conversation with retired Colonel McKeon, and part of that conversation was you said that you had some options that you were exploring, or you had a course of action that you were going to take, right?
Yes.
And you asked him if he was going to do anything?
I said, are you doing anything? Yes.
No. Suppose the colonel said, you know what, Joe? No, I'm not going to do anything. You wouldn't be able to tell him otherwise, would you?
He's a colonel.
Right. So you're not going to tell him how to do his job.
I'm not going to tell a colonel how to do his job, no.
And so I'm talking about a different version of the colonel that doesn't exist, that might not be as enlightened as the colonel is. So when he's the one that came up with the idea that learning of these new circumstances that he wasn't aware of, he says, you know, I think I can actually do this. That was his suggestion, right?
We never really discussed what his suggestion was. He said he was going to look into it. He's going to get back to me. After I had talked to him about, I don't think it's too late to do something, but he said he was going to get back to me.
So he was never acting under your direction.
No.
And as far as these statements, I mean, you sat here through a couple of, let's say, quite prominent jurists and a clerk of 47 years who have all stated that the manner in which someone acquires a substance has absolutely no bearing on probable cause. You sat through that testimony, right?
I have.
And as a minister of justice employed in Worcester County, you agree with those assessments?
I do.
And so you do agree that statements such as these, which are not admissible at trial, that you agree with that as well, right?
Yes, yes. And also from being a defense attorney for 17 years, yes.
So you'd agree that a statement that's not admissible at trial, as these judges have all indicated, it in no way contributes to the successful prosecution of a criminal case. That's an accurate statement, is it not?
Yes.
Now, you asked how many OUI reports you've looked at, and I believe the response was not many. Have you ever seen in your entire career an OUI report with statements like these in them?
Just one thing on your question. I haven't seen many that year when I was DA. I've seen thousands. I represented hundreds of people with regards to OUIs. I was an assistant district attorney. I saw thousands of OUI reports as well. But no, I've never seen language that specific, that graphic in a police report, an OUI arrest report. Never. This was a first.
Especially, this has nothing to do with the probable cause of the charge.
Nothing to do with probable cause.
I have no further questions.
Okay, once again, I have another question, which indicates how closely my fellow commissioners are listening in, that they're sending me these questions. So, sir, did your office ever conduct an investigation into how the state police report was made available to the public and the media after impoundment?
We didn't, but I asked the Attorney General to do it, and I asked ethics to do it. I talked to Tom, again, I got advice from Tom with regards to that as well, because there's a 6-year statute of limitations on this. But no, I did not feel it was appropriate for me to conduct an investigation when I was being questioned about all of my activities with regards to this matter. But the statute of limitations has not run.
I do have a follow-up question to that.
With respect to that, I do not.
Okay, very good, thank you.
Neither do I.
Okay, well, okay. Do you want to go, is it Mr. Bourgeois? Do you want to go? I can't remember the order we've been going in. Are you going to cross-examine him now, or is it Mr. Bourgeois?
I've been waiting for 9 days.
Okay, you've been waiting for now, well, okay, it's here, okay. You have the opportunity, thank you.
Oh, thank
Okay, thank you, thanks.
Sir, had we ever met prior to sitting next to you for 9 days?
No.
We need an investigation to know who leaked this to Turtle Boy. You know who leaked it, don't you?
Pretty good idea, yeah.
The questions keep reoccurring. Have we ever seen a case like this, or have we ever had to get involved in a case with this much publicity? You deal with publicity cases all the time, don't you?
Yes, we do.
And you talked about this language about being a minister of justice. That's kind of like a fancy word for doing the right thing, isn't it?
Yeah, it's in the comments. I'm not just an advocate. I'm a minister of justice.
Aren't you supposed to convict everybody that you indict and charge?
I ran on a theme of prevention. I'd rather prevent the crime than have to solve a crime. In law enforcement has changed. No, it's not all about conviction. It's about doing the right thing.
So the question is, when you got this information, are you the one that sought the impoundment of this document?
No.
You did.
Kara Colby, the defense attorney for the defendant.
And like your responsibility, your job, does she have a job as well?
Yes, I've won that hat as well. I used to be a defense attorney. Yes,
You ever file a motion to impound?
yes.
And under different circumstances, forget being a DA for a moment. As a defense attorney, you read that report, you're given that report when you show up for the arraignment, right?
Right.
And just for those who don't know, what's the arraignment?
The arraignment session, when there's a formal reading of the charges to the defendant, they usually waive the formal reading of the charges. They sit there with their attorney, and the prosecutor makes a case with regards to the charges itself. And it enters into the criminal justice system at that point.
If there is an issue about bail, does that record, that police report, is that potentially going to be read into the record?
not in Worcester County.
Okay, forget about Worcester County. Is there a potential that the contents of that, if it wasn't impounded, would become public and have public have access to it?
No. It's usually, you
Well, what's
talk,
the purpose of impoundment if the public's not gonna have access to it?
once the case is arraigned, once the charges have been brought, it's put into a public file. In Worcester, it's then brought back to the clerk's office. There's a pile of files that are there for the media to come in and then go through everyone. It becomes, at that point, it's accessible to anybody who wants it, not just the media, but a blogger, anybody. They can come in and go through that file.
Okay, that clarifies it. So at some juncture on the 17th, after the arraignment, that document becomes public if it's not impounded.
Yes, correct.
And you've impounded documents before as a defense attorney, have you not?
Yes.
And had you been assigned as her defense attorney instead of a prosecutor, would you have filed a motion to impound?
Absolutely.
Why?
Several reasons. First and foremost, it's a fundamental right to have a trial, all right? Free of pretrial publicity. That gets out with those, the factors that are in this, the three different factors. Those are the things that are just gonna bring down heightened condemnation. She's gonna get crucified, she's gonna get killed. And it's all gonna come out in the media, it's all gonna come out in the public. It was already flying through the courthouse. Those are the things that would kill your right to a fair trial.
So ultimately, the case is transferred to Framingham District Court, was it?
Yes, I believe so, yeah.
She, as they say, admits to sufficient facts, right?
I believe so, yes.
Okay. And even before she does that, there's all this discovery, all this publicity about her case, isn't it?
Yes.
You think she had a fair access to the criminal justice system as a result of that leak?
No, she was made to suffer.
That's what you're trying to avoid, isn't it?
I get in this business to help people. You know, you don't. You don't. Well, one of the hardest parts of my job is talking to people in pain. You don't make people needlessly suffer that are already suffering. Follow my rules. And you try and, every one of my DAs has the mantra, show compassion and empathy, stay within the law, especially when it comes to drugs and alcohol. Violence I abhor. Violence is a game changer. I've seen violence and its effect on people, but the drugs and the alcohol, they're a disease, which we're trying to help us. Yeah.
Did you do anything in terms of your action as the district attorney to award or provide an unwarranted benefit or privilege to Judge Bebo or her daughter, his daughter rather?
No, we would do that for anyone. We would do that for anyone.
The fact that
If it was brought to my attention, I would do that for anyone.
Yeah, I have a few, well, once again, these are not my questions, the questions from my.
You have in your possession.
I do. Thank you for clarifying that. So, okay, sir, once again, and this is another question from one of the commissioners. I neither know nor care which commissioner. As the district attorney and a public employee, you have access to the State Ethics Commission and the Attorney General's Office for ethical and legal guidance. Did you make any contact with either agency when the underlying case arose in October 2017? And if not, why not?
No, I didn't. I rely on Tom Kiley for my legal advice.
Okay.
Well, did you think that there was any ethical violation by
Absolutely not.
doing what you did? Did you feel any need?
I thought that.
Hold on a minute. Try to narrow it down a little bit,
Yes.
okay? Did you feel that you had done anything to violate the State Ethics Commission rules?
Absolutely not.
Did you contact them and ask them to investigate the release of that information?
No.
How about the AG's office? Did you ask them to investigate that?
No, I thought.
I meant the release of the leak.
Oh, I asked the AG, I asked the three people that were interviewed, bring in the blogger, bring in the head of the state police union, bring in his attorney, ask them what they know about the league. I asked the same thing of ethics. I bring them in, because that's going to tell you why this went the way it did.
Any more, Judge?
Another question here. Was there any concern on your part that the judges in Worcester County would look unfavorably on your performance if your office prosecuted a case involving a judge's child who had a substance abuse problem?
Yeah, I believe, yes, that's why I was looking to get it to another, either a special, not a special, in this case, I wanted to go to another district attorney's office for transparency's sake.
Okay. If he had kept it there and given her some special benefit and dismissed the case, there may be some concern about special treatment under those circumstances, wouldn't it?
Yes,
Did you make the decision to have it transferred from Worcester County to Framingham, or did Judge Dawley make that decision?
no, that's my decision. They weren't my first
Hold on a minute,
choice.
no.
Oh,
To have the case.
that was Judge Dawley.
Okay.
I'm
Say
sorry.
it again. Who made the decision to have the case transferred from Worcester County to Middlesex County?
Judge Paul Dawley, Chief Justice.
It's not your decision, right?
No, it's not.
You don't control the trial court, do you?
No,
Okay. Do you have the option to have another prosecutor outside your office who is not paid through your office prosecute that case?
yes. We can hold on to it or we can give it to someone else.
What did you do?
We gave it to someone else.
Well, when you say someone else, just so the record is clear, someone else who's not on the payroll for the Worcester County DA's office.
We gave it to the Middlesex District Attorney's Office.
You call it Middle District?
Middle District, yeah, we don't, Worcester County, we picked up Bellingham and we lost Athol, so it's 60 cities in town, they're all, 59 of them which are in Worcester County.
You do anything different for somebody else who is the proverbial, and I don't mean to demean a truck driver or a custodian or some blue collar worker, but if some blue collar worker comes in there with his child, his 28-year-old child, has got an addiction to heroin under the same circumstance, and the law enforcement officer wrote that about her, would you do anything different?
It was brought to my attention, I wouldn't have done anything different.
Okay, thank you, sir. Okay, Attorney Bourgeois, do you have any questions, sir?
You doing that deliberately, Judge?
Yeah.
Yeah, you're a moot, Ms. Bourgeois. Okay,
All right,
thank you,
how's
sir.
that? Can you hear me now?
Yes.
All right, good afternoon, Mr. Early. Just a couple of questions. First, at any time, did anyone in your office, including yourself or Mr. Travers, suggest replacing the report that had been on file with the clerk's office?
No,
In the order to show cause, at paragraph 12, it's the order to show cause against my client, Mr. Travers. It says, and I quote, "Early directed Travers to go to the Worcester County District Court Clerk's office and replace the original report of the daughter's arrest with the revised arrest report." My question is, did that in fact happen?
absolutely not.
In paragraph 13, it says, quote, "Travers went to the clerk's office and attempted to replace the original arrest report in the court's file with the sanitized revised report." End quote. Sir, did that happen?
Objection.
Yeah, I'm not sure he would know that, so that's sustained.
Well, Mr. Travers is your subordinate employee, isn't he?
Yes, he is.
And the order to show cause at paragraphs 10, 11, and 12 refer to supposed directions that you gave to Mr. Travers. Isn't that right?
I'd have to look at it, I take your word for it.
But did you give any directions to Mr. Travers about the initial report or about the revised report?
With regards to the original report, no. With the revised report, I just said my instruction was to him, was to go down and see what's going on with this.
And to your knowledge, did he do that?
Yes,
And when you told him to go down and see what was going on with the case, had you even seen the revised report?
I had not.
And did you know what the revisions were going to be?
No,
And when you told Mr. Travers that there was a new report coming down, did you even know what was going to be in the new report or what type of report it was?
I did not.
That's all I have. Thank you.
Okay, thank you very much. Petitioner? Do you want just a couple of minutes to consult with your, what's that?
Yeah, just a couple minutes. Would that
Okay,
be
why don't we, yeah, sure, why don't we take 10 minutes, is that okay?
Sounds good, thank you.
That's, okay, thank you very much.
Judge, we say 10?
What's that?
Can you give us a time to exact?
Okay, let's say, well, it's 3:45. Why don't we make it real easy, 4 o'clock?
Perfect.
Okay, we'll make it real easy, okay?
Good afternoon, District Attorney Early.
Good afternoon.
I believe you testified on direct that in your first conversation with Colonel McKeon, you indicated that Judge Bebo's daughter got arrested and the arrest report was pretty graphic. Was that your statement on direct?
I don't believe those were my exact words, but that's pretty close.
Was that what you said on direct today?
I'm not sure those were my exact words, but it's pretty close.
You were interviewed by the Attorney General's office and asked questions about your actions regarding the judge's daughter's arrest report, and you refused to be recorded. Isn't that right?
I asked not to be recorded, yes.
The judge's daughter's arrest report was impounded on October 17th, 2017, correct?
Yes,
And so there were no public statements in that case after the impoundment on October 17th, 2017, correct?
Objection. Well,
Right, yeah,
I'm sorry, Judge, I'm sorry to interrupt, but when you say there are no public statements, are we talking about from his office, from the state police, David Procopio? I don't know what the context of it is, sorry.
okay, well, he did answer the question, so the witness was not confused. But, if you want to clarify that on recourse, you can. Get Ms. Pruitt.
Did I understand you to testify that you interrupted Judge Despotopoulos' arraignment on in the second busiest courthouse in the Commonwealth to discuss scheduling?
no,
You would agree with me that violation of an impoundment order is a criminal matter.
I would agree to that, yes.
And you do understand that the Ethics Commission is a civil enforcement agency, correct?
If you say so, yes, I would believe that you are civil, yes.
Operating under the influence of alcohol and drugs is a public safety issue, isn't it?
Yes,
And in fact, you were part of a press conference with Governor Baker in 2021 regarding Trooper Thomas Collardi's law, is that correct?
yes,
And Trooper Thomas Collardi was killed by a motorist who operated under the influence of drugs, isn't that correct?
I believe the operator was found not guilty of operating under the influence. I believe it was negligent operation and manslaughter.
What was the purpose of Trooper Thomas Collardi's law?
Could you be more specific?
I'm sorry, didn't you participate in the press conference for it?
I did,
And you in fact spoke at the press conference?
I did.
You prepared a speech at the press conference?
I don't know if I had a prepared speech, but I did speak at it, yes.
The arrest of a truck driver's daughter is not Sam's worthy, is it?
What do you mean by SAMs?
When my brother counsel questioned you earlier, didn't you mention SAM's situational awareness message system? Didn't you reference that?
Yes,
And the arrest of a truck driver's daughter is not Sam's worthy, is it?
it would depend.
You gave a statement under oath to the State Ethics Commission, is that correct?
Yes, I did.
And you were represented by counsel.
I was.
That was April 3rd, 2019. 2019, is that correct?
I believe that's the date, yes.
Is a statement under oath?
It was under oath.
You told the truth.
I did.
Nowhere in your statement under oath before the commission did you use the terms probable cause narrative or probable cause statement. Isn't that true?
I answered your questions. I don't know if you asked me a question about that. I don't know. I didn't give a narrative.
I'm sorry. My question to you just now was you didn't use the terms probable cause narrative or probable cause statement in your interview before the State Ethics Commission. Is that correct?
I don't remember.
Okay. Throughout your statement under oath, you use the terms arrest report and police report. Isn't that correct?
It is.
And with respect to report writing, you once told a group of new troopers, quote, listen to your supervisors, you listen to the people who are training you. Isn't that correct?
I believe, yes.
Respondent Travers' father was a judge. Is that correct?
Yes,
You described him as a very good judge.
yes,
Jane Sullivan, who also works for you, her father's a judge, correct?
yes.
And you appeared before him as a lawyer.
I did. I tried cases in front of him, yeah.
You and Judge Bebo ran in the same circles, is that correct?
What do you mean ran in the same circles?
Okay, so could Mr. Jha, could you please pull up Mr. Early's transcript before the commission?
Is that an exhibit, ma'am?
It is, actually. It was entered, 34.
Okay, that's
Exhibit 34. Thank you.
okay, thank you. Exhibit 34.
And I'm gonna direct, oh, I'm sorry. It's my letter.
Here you go, sir.
Thank you.
District Attorney Early, I'm gonna direct your attention to page 19. I'm gonna direct your attention starting at line 14.
Yes,
And the question is, how did you know him?
yes,
And you responded socially, we ran in the same circles sometimes.
yes.
Okay, so that was your testimony regarding Judge Bebo, correct?
Yes, it was.
And in fact, you went on a golf trip that Judge Bebo organized on the Cape, isn't that correct?
Yeah, in the 1990s, early 1990s.
But you went on a golf trip.
I did. I did.
Now, Colonel McKeon worked for you when you became a district attorney, correct?
Colonel McKeon was the head of my state police detective unit, my first state police detective unit commander when I got elected, yes.
You asked him to run your state police detective unit, right?
Yes, I did.
You considered him a good friend.
Yes, I did.
You played golf with him in Florida once or twice, correct?
Twice, I believe.
And you went on a spring training trip with him as well?
No, the same trip we went over and caught a baseball game.
So one of the two golf trips, you also went to a spring training
Yes,
event.
yes.
I would like the witness to be shown stipulated exhibit 11, which we have emailed to Mr. Bourgeois. Mr. Jacques, you can take down his transcript for now. That is Mr. Early's cell phone records. I didn't want to put his full cell phone records
Good,
up
thank
on the
you. I
screen, so
I
sent
appreciate
a
that.
copy of it to,
Thank you.
Mr. Bourgeois. I'm gonna direct your attention, you have your cell phone records in front of you?
Yes,
Alright, so I'm gonna direct your attention where it says, page 13 out of 26 at the top.
yes,
And directing your attention to the October 17th, 11:33 a.m. call. Do you see that?
I see, yeah, I see a bunch of them.
Okay, so it's 5 from the bottom,
Yes,
and that's a call to Colonel McKeon, correct?
I don't know. It says Hopkinton, Mass.
So you don't know if that's his phone number?
I don't.
So, I believe Mr. McHugh's cell phone number was, verified on the
Can
record.
we stop right there?
Yeah, what do you want to say?
Well, I don't want the phone number publicized.
No, I understand that, but hold on. Perhaps, Mr. Kiley, can you confirm, or Mr. Wasconi, can you confirm that that's his phone number? Okay, so that is, Colonel McCune's phone number, okay.
So there's a call to Colonel McCune on October 17th, 2017 at 11:33 a.m. Is that right?
Yes.
Let's turn to the next page.
Do we have the duration, please? I don't have the document number, that's one.
Okay.
Would you like to say on the record how long, the duration of that call?
2 minutes.
Page 14. October 17th at 12:33 p.m. to Mr. McKeon. That's 1, 2, 3, 4, 5, 6 lines down. Do you see it?
Yes, I do.
What was the duration of that call?
5 minutes.
Right, and down 2 more at 12:40 p.m. Do you see that call to Mr. McKeon?
Yes,
How long is that one?
1 minute.
Further down, about midway through the page, October 17th at 5:44 p.m. Do you see that one?
Yes,
What's the duration of that call?
4 minutes.
Right, directing your attention to the next page. October 19th at 8:10 a.m. Do you see a call to Colonel McHugh?
Yes.
What was the time?
8:10 a.m.
Okay, thank you.
And how long was that call?
2 minutes.
And then the very next entry at 8:17 a.m. call to from Colonel McHugh. Do you see that one?
I don't know how to tell if it's from or going out.
Do you see where it says incoming CL? Just before the time?
No. Where,
May I approach?
Sure, yeah, why don't you point it out to him?
So we just continue out.
okay, thank you, yes, I see it.
You're welcome. And what was the duration of that call?
4 minutes.
Right, directing your attention down the page, also on October 19th at 5:40 PM. It's maybe 2/3 of the way down,
Yes,
right? And that's also an incoming call. Do you see
Yes.
it from
Yes, I
Colonel
do.
McKeon? And what was the duration of that call?
5 minutes.
Yeah. I'd like you to hold on to exhibit 11. And this may take you a moment. But on October 19th at 4:07 PM, and this is on page 15 of 26. Do you see the call to Attorney Kiley?
Yes,
And do you see any calls from October 16th through that time to Attorney Kiley? To the one that you just identified on October 19th?
Perhaps to save some time, is he gonna find a number there, or there's nothing?
Maybe
I
we
would
just
submit
direct
he
them.
would not.
What's that?
Maybe we just direct them to shorten it up.
Yeah,
Yeah, sorry.
there are none before October 19th. But I was giving him an opportunity, perhaps he would find one, but
if
you were
there's not one
unable to
there, I'll
locate it.
take your word for it. You wanna keep looking?
Is there something that indicates Attorney Kiley on that?
Here's your phone
It's
number.
one of your numbers.
What's the number, please?
No,
Don't
So
see
you
it.
don't want
I
the,
don't, okay, well, I want business.
Well,
You don't have a cell phone,
it ends in 775.
okay. You can
Okay,
read that one.
okay.
And Attorney Kiley
Okay.
does not have a cell phone, does he?
Yeah, he does.
Does?
You did? You didn't know how to, but it was like a flip phone. All right.
Okay. The next page, 16 of 26, October 20th at 1:51 PM. Do you see a call to Attorney Kiley? It's at the top of the page.
Yes,
And then on the next page,
Judge, I'm sorry to interrupt. Can we have a duration for each one of those calls?
4 minutes.
okay, so that's 4 minutes, but the call on October 19th at 4:07 to Attorney Kiley, what was the time on that?
On the 20th, Judge, what?
Yeah,
the
the
19th.
October 19th at 4:07.
Three minutes.
You can hand exhibit 11 back to the presiding officer.
Thank you.
No, you never spoke with Judge Bebo in October 2017 about his daughter's arrest, did you?
No, I did not.
And that was despite your concern for her substance abuse disorder?
We didn't chat in October, no.
But this was despite your concern about her substance abuse disorder.
There was a whole
You didn't reach out to him, right?
No,
And this is despite knowing that the case was being transferred to another county, correct?
I didn't talk to him in October, no.
And in fact, you decided that the case would be transferred to another DA's office on the day that you learned about the judge's daughter's arrest, isn't that right?
I knew I was gonna be transferring it, yes.
On the day you learned
Yes,
that you've been arrested, okay. Now, the rules of professional conduct, they did not apply to the state police, isn't that right?
they do through me.
When you contacted Colonel McKeon about the arrest report of the judge's daughter, you didn't expect him to do anything about the arrest report, correct?
I didn't have any expectations from the colonel.
When you called him, you didn't expect him to do anything about the arrest report, did you?
I did not have any expectations of the colonel.
And if the rules of professional conduct applied to him, you would expect him to do something, wouldn't you?
They applied to him through the district attorney.
You said you wanted to let him know that his coat was on fire, is that right?
I did.
Because there would be criticism of his office?
I thought he himself would be potentially criticized. Yes,
And I believe you said Mr. McKeon's response was, there's enough people that hate the state police already, we don't need to be adding to that, is that right?
as part of his response, yes.
So your initial conversation with Colonel McKeon was about criticism to him and the state police, but not actually doing anything, correct?
Could you repeat that?
Sure. Oh, could you replay the question? Thank you.
So your initial conversation with Colonel McKeon was about criticism to him and the state police, but not actually doing anything, correct?
I don't understand your question.
So in your first conversation or the next, you told Colonel McKeon that the case was impounded?
I believe so, yes.
And other than the arrest of the judge's daughter, you don't ever recall having a discussion with the colonel of the state police about a specific arrestee, isn't that correct?
Yes,
You spoke with Judge Dolly on or about October 20th, 2017, is that right?
I spoke to him several times.
You specifically spoke with him on or about October 20th, 2017?
I believe so.
You told Judge Dolly that you had a motion to redact.
I don't remember telling him that I had a motion to redact specifically. No, I told him I thought we were going to redact. I don't remember saying we had a specific motion to redact.
You told Colonel McKeon that you were filing a motion to redact.
I did.
You left a voicemail for Secretary Bennett that you were filing a motion to redact.
I don't remember that.
Judge Dolly told you that the motion had to be filed with the clerk and heard by a judge.
He told me that if we were putting something in, it should be heard in open court on the record. I remember that in front of a judge.
You did not have a motion to redact at the time you spoke with Judge Dolly.
We did not have a written motion, no.
You had a revised report at the time you spoke with Judge Dolly on October 20th, 2017.
I did not have it, no.
Did your office have a revised arrest report
I
on
believe so.
On October 20th when you spoke with Judge Dolly?
I believe so, yes.
Did you testify?
Wait a minute, I'm not sure about that. I'm not sure about that.
You testified under oath that you didn't know about the motion to redact, isn't that true?
Could you repeat that?
I should take back the question,
Just
please.
raise your voice a little.
You testified under oath that you didn't know about the motion to redact, isn't that true?
Which motion to redact?
Is it your testimony that there was more than one motion to redact?
Jeff Travers made a motion to redact. Yes, there were more. there were more than one discussions about motion to redact, yes.
Different question. You testified under oath that you did not know about the motion to redact. Isn't that true?
Can you be more specific?
Mr. Jacques, could you please put District Attorney Burley's sworn interview on the screen, please?
What exhibit is that, please?
That is exhibit 34.
34, I'm just gonna.
34.
34, thank you.
Yeah.
Thank you.
Page 83.
What's the page, please?
83.
83, thank you.
Directing your attention to line 10. You see that?
Yes.
Question, it says, we're on the record after a brief break, and the question is, who first raised the idea of redacting the judge's daughter's arrest report? And your response was Travers, correct?
Yes.
The next question is, who did he raise that idea with? And your response was with the judge. Did you see that?
Yes.
And the next question is, did he speak with you about redacting the arrest report? And your answer was not before he did it, after, yes. Is that
Yes.
your statement under oath?
Yes, it is.
And then the next question is, when you say not before he did it, you mean not before you actually redacted? And your response was, mm-hmm.
Yes.
So rather than filing a motion to redact, which you testified you didn't have, you went to speak with Judge Despotopoulos, is that correct?
No, that's not correct. That characterization is wrong.
I'll direct your attention to page 78 of your statement under oath. Starting at line 16, question.
What page?
78,
Yes.
line 16.
Yes.
Question, why at this point didn't you have your office file a motion in court to substitute the revised arrest report for the original report rather than going to visit Judge Despotopoulos? Did I read that correctly?
Yes, you did.
And your response was, I just wanted to have the conversation. I hadn't had a situation like this before. I thought they could give me some guidance with regards to this. I wanted him to know there was a new revised report. Did I read that correctly?
Yes, you did.
Why couldn't you file a motion? Did I read that correctly?
Yes, you did.
I guess we could have. That was your response, right?
Yes.
The question next was, why didn't you? Correct?
Yes.
And you said, I thought we should have a conversation again. Is that right?
Yes.
I thought the judges were going to be pretty mad about this. I didn't know if they'd be blaming me, the state police, try to keep good relations. And after my conversation with Judge Dolly in the morning, I got the impression that they were pretty upset about this and the language in the report. Did I read that correctly?
Yes.
But you didn't file a motion with the court, correct?
No.
You thought you should have a conversation, correct?
I testified to that. Yes.
Thank you. Now, according to you, Judge Despotopoulos and Clerk Keenan told you that the new revised state police report and the original state police report were going to go into the file, correct?
Keenan did. I don't believe Despotopoulos did. Clerk Keenan said they would both go in the file.
directing your attention to page 85 of your statement under oath.
Yes.
Starting at line 22.
Line what?
22.
Okay.
Yes.
Question, well, what did you learn when you were talking to Judge Despotopoulos and Brendan Keenan about what was going on with the revised arrest report? And your answer's on page 86, right?
Yes.
I thought that they both go in the file. That was the impression I was left with. Both impounded and revised report would be also docketed and put in with it. Did I read that correctly?
You sure did.
Meanwhile, you told ADA Travers that he was the point person to receive the revised arrest report, correct?
I told Jeff to be on the lookout for a report that was coming down, yes.
So I want to make sure I understand this. You spoke with Judge Dolly, the first justice of the District Court for the Commonwealth of Massachusetts. You said file a motion and have it heard by a judge, right?
No, he didn't tell me to file a motion. He said if something came down, it should be done on the record in open court.
Then you met with Judge Despotopoulos and Clerk Keenan, who, according to you, told you that the original and revised reports should be in the file, right?
Not Judge Despotopoulos, but Clerk Keenan.
Let's talk about publicity. Publicity. Now, the publicity in this case was based on what you and the state police did regarding the arrest report, not anything the judge's daughter did or said. Isn't that
Objection.
correct?
That's a mischaracterization of the evidence, Judge.
Well, you know, you can
said,
clear.
no, she's saying that if the publicity came about as a consequence of what they did was properly go and have it impounded by a court.
Okay.
It's the breach of the impoundment that generated the publicity.
Okay, well, you know, she can ask the question, you objected, now you have to have the question again, so.
I have the question read back.
Now, the publicity in this case was based on what you and the state police did regarding the arrest report, not anything the judge's daughter did or said. Isn't that correct?
Yes.
That's kind of a confusing question, that's a stay, you can certainly go into the stand and ask whatever questions you want, but I think that question's a little confusing.
Okay.
But feel free to explore that area, I was a little confused also.
Sure, thank you. Mr. Shaw, could you please pull up the Boston Globe article dated November 9th, 2017. Headline, Baker investigating why trooper was ordered to change police report.
It's the leak to Andrea Estes, by the illegal leak to Andrea Estes.
Counsel, and I don't know if counsel's testifying or
Okay,
just.
yeah, he is.
Is this an exhibit?
No, this is cross-examination.
I just asked a simple question, I just wanted it's an exhibit.
No, it is not.
No, it is not.
No, it is not.
I object to any representation that the Boston Globe article is pertinent evidence.
You know, she can have the question, yeah, so.
Thank you.
Yeah.
So you see the headline of this Globe article dated November 9th, 2017?
I'm assuming it's a headline, yes.
And does that headline reference the judge's daughter or any statements that she made?
Are we asking him to read the
I object.
document?
I mean, we're at the stage now, I know it's an adjudicatory hearing, but we're at the stage now where we're allowing cross-examination from a Boston Globe article that doesn't have, it's just the headline. Wait, seriously,
Well,
how is that relevant, how does that connect to this?
Well, you know, first of all, I'm assuming she wants to explore the area of publicity and she's bringing up the Boston Globe. along those lines, and you're free to cross-examine, obviously, and if there's something in, do you have this document?
I'm sure I read it, but I don't have it now.
Okay, so,
The same is true of me.
what's that?
The same is true of me. We had no idea this was coming up today, but
Okay, so,
I've never seen the document at all.
can you just share that document with them?
Sure, we'd be happy to.
Okay, so I don't know who's gonna, we're starting to get late here,
This
it's,
is
you know.
4:36 in the afternoon.
Okay. Well, you know what I'm gonna do?
They're also public records, they can.
No, I'm not,
find them.
I'm not, you know, I'm indicating that I'm gonna allow you to ask certain questions, but in fairness to them, they should at least get to see the document that you're discussing, you know, especially when, you know, all we see is the, you know, the headline, you know, without, I don't see any text there. So in fairness to them, I think they're entitled to take a look at that. So why don't you continue with your cross-examination, and we'll return to this either later today or tomorrow morning first thing.
Thank you. Mr. Shaw, could you please now turn to the Globe article dated November 7th, 2017?
objection.
Well, I take it it's the same objection that you haven't seen this. Well, you know, in fairness to them, they should have seen all these documents, especially since you were planning on introducing them. So I'm gonna do the same thing. I have no problem with you asking these questions at this point. The only problem I have is that out of fairness to the other side, they should be provided a copy of that.
We will provide a copy of these documents as soon as I've done. I mean, I've provided them, I have them in a format where I can just forward it to all of them.
Okay, I appreciate that.
Not disputed exhibits.
But this is cross-examination,
Understood.
so.
Understood.
Go ahead.
Excuse me,
So,
Mr. Kantrowitz? Two things. Number one, I'm hearing everybody well except for Ms. Pruitt. And if there's something she could do to speak more directly towards the microphone, I can hear the witnesses, I can hear you fine. Secondly, I think under the doctrine of completeness, we shouldn't be seeing headlines divorced from stories. We should see the entire document or none of them.
I agree. And that's why she's gonna provide it to you before she asks any more questions. And then, once it's provided to you, then she'll be up to ask. She'll ask a question and you can object or not object, but at least you'll have the entire document in front of you.
if I may,
Sure.
what's on the screen, the rest of the document is there. It's not just the headline. My question is going to be as to the headline, but the entire document is there. I didn't think that we wanted to spend the
No, you don't.
commission's time.
I disagree. I can only see what appears on the screen. I cannot see the rest of the document or scroll down through it.
Okay, you know, I've made my decision. There's not gonna be any more questions on this until the parties get to see the entire document. It's basic fairness to them. So, yeah, Mr. Scott.
One concern I have, we're about to go into the pretrial publicity, prejudice, that sort of thing. Those articles are exactly what we're talking about when we mean pretrial publicity, which is essentially trying the case via media. Again, I just don't see how that's relevant to, I just don't see the relevance. I think it is
Okay, well,
exactly the thing we're trying to avoid. It's exactly what brought us here today. That's just my 2 cents.
Okay, well, I appreciate that. I've made my decision. She's not gonna ask any more questions on this for now until she provides everybody with the document. And if there's an objection, you'll object and I'll rule on it then.
If
Okay.
I may, the respondents have spent a fair amount of this adjudicatory proceeding.
I just ask you to
talking-
keep your voice up, please.
Sure. The respondents have spent a fair amount of this adjudicatory proceeding discussing the publicity in this case. And I believe Attorney Burke asked several witnesses, have you ever seen publicity like this? In this case, no, I've never seen anything like it, but you know, what I'm bringing out now is that the publicity was not about the judge's daughter or what she did or what she said. It was about the actions of the respondent, and I think I should be allowed to to.
I'm not
to
disallowing you. I'm allowing you to do it. All I'm saying is that before you do it, just give that document to the other party so they can review it. You can, as I said, you can do what you want to do, but please just get the document to them.
Mr. Cole. May I have a moment, Mr. Cole?
Now, is Mr. Cole now going out to make copies of this?
He's going to make copies.
Okay, so thank you.
Mr. Early, you testified under oath that when the judge's daughter worked for you, you saw changes, physical changes.
Yes,
Do you recall making those statements?
I do.
Losing weight, you testified? It's in
Yes.
the record.
Yeah, I understand it's in the record, yes,
Withdrawn,
yes,
shallow face.
yes.
You did nothing, right?
No, that is not true.
You put this exhibit in stigma. Sister's nephew, grandmother, cousin, brother, niece, grandfather, mother, it's not a junkie, it's a mother, father, et cetera, et cetera.
Yes,
Last thing,
Again, could I have that question read back? I cannot hear what she's saying.
Can you please repeat the question?
could you read back my question, please? I hadn't gotten to my question
I
yet.
know, I realize.
You put this exhibit en stigma. Sister's nephew, grandmother, cousin, brother, niece, grandmother, it's not a junkie, it's a mother, father, et cetera, et cetera.
So you're reading, what is it you're reading from, so the record is abundantly clear?
I believe this is exhibit
Was it admitted?
Was admitted.
54? Exhibit 54.
Okay, thank you.
The last thing it says is ask how I can help. Is that right?
yes,
You didn't ask the judge's daughter how you could help, did you?
no, we did.
You did not ask the judge's daughter how you could help, did you?
You just answered the question.
I just don't understand it. A prosecutor talking to a defendant's daughter after she's been charged, is that the point you're talking
No,
about?
not at all.
Okay.
When she worked for him.
When
This
she what?
when she worked
Oh,
for
okay.
him.
Okay,
These statements are things that he witnessed regarding
okay,
this young person
Okay.
when she worked for him.
okay, well, I
And
did
he,
not hear
and he
that.
puts this
Okay.
statement, this exhibit in the record saying, asking, how can I help? And my question to him is, did he ask her how he could help?
And the question was answered.
And the answer was we. My question is you. Did you ask her, how can I help you?
I asked her supervisor to ask her if she needed help.
You didn't reach out to her father even though you knew him, right?
I don't know if we had conversations about, I don't remember if we had conversations about his daughter or not.
When Dan Bennett confronted the judge's daughter about possible substance use disorder, indicating that the office wanted her to go into treatment, you didn't do anything, right?
Told Dan Bennett not to confront her, but to talk to her and to see if she needed help.
You denied knowing that Dan Bennett spoke with her, isn't that correct?
I believe I did say something like that in my ethics testimony again. It's been
Thank you.
4.5 years, I believe. I told Danny to handle the situation.
Colonel McKeon told you that he was issuing a revised arrest report, isn't that correct?
He said he was sending down a new report, I think was his language.
Directing your attention to page 52 of your sworn interview.
I don't have it.
Yeah, well, I'll just get it. What exhibit, is that 34? Is that 34?
Yeah.
That's good, thank you.
I'm gonna ask that you hold on to this
Okay.
until we're done. All right, and so directing your attention to page 52
Yes,
and starting at line 16.
yes,
Question, at some point, did you become aware that Colonel McKeon intended to issue a revised arrest report? Did I read that correctly?
yes, you did.
Yes, period. Correct?
That's part of the answer, yes.
Yeah, we'll get to the rest of it, but it's yes, period, correct?
Yes,
All
period,
right.
yes.
He called me back. I don't know if it was that day, the next day, or the day after. He said a new report was coming down, and I said, do you want us to pick it up? Do you want someone from the Mass State Police to pick it up? And he said, no, I'll have someone, would drop it off at your office at the front counter. Did I read that correctly?
Yes, that's accurate.
And you denied knowing what was in the arrest report. Is that right? The revised arrest report.
I hadn't seen it, you know.
Let's have a moment.
Sure. Thank you.
Sure you are.
What's that? No, yeah, this thing I have.
I'm good, thanks.
Oh, yeah, do you
I
need
got a-
more?
yeah, but thank you for asking. I got a little bit left.
I asked you earlier whether you interrupted Judge Despotopoulos' arraignment to discuss the scheduling issue. I should have asked, did you interrupt his arraignment session to discuss a scheduling issue?
No, I didn't interrupt them.
I would like to suspend until Mr. Cole returns and then complete my cross.
You know what, Judge, I'll withdraw my objection, but let her go ahead, it's 10:05, it's time to move this on, I withdraw my objection.
Okay, so,
I sent the documents.
Oh, it's all right, just go ahead.
they're going to get it eventually, but they're,
The miracle of the internet.
oh, wow, oh, okay.
Some people don't believe in miracles, but internet miracles, but fine,
But it's time to get into the 1990s, right?
sorry.
So, perhaps, Mr. Burke can share that with Mr. Kiley, Mr. Rusconi, and Chicky
another-
it also, and I know that, I don't know what Mr. Bourgeois is doing.
it, thank you.
It's November 9th,
The
2007.
internet didn't get here.
Okay, so, okay, I'm gonna, he's gonna come back with those documents and then, but apparently we don't have to wait for him at this juncture, so I'm gonna allow with, since the objection has been withdrawn, to allow Ms. Pruitt to ask whatever questions she wanted to ask on that topic.
Yes, however, I sent the documents away, so I don't have them.
You wanna borrow an
So
iPad?
if we could take a brief recess, I'll go grab the documents and that'll be that.
Rather than take a brief recess, let me just, for scheduling purposes, I hope to be done with this witness today, even if we have to run a little late. So is that okay with the parties if we run?
Yes, please.
Yes.
What's that?
Yes,
Yes.
please.
Yes, okay, so,
Yes.
no, okay, so everybody wants to finish today and, well, how late we gonna stay kind of depends on how many questions you're gonna have on read the rec.
I don't think there's a lot we're gonna do.
What's that?
I don't think there's a lot for us.
Okay, so,
I think we'll be out of here, depending upon Mr. Cole's quick feet. I think we'll be out of here before 6 o'clock. I don't know what time it is now, though, because I also don't have a watch.
okay, it's almost 5
We
o'clock.
should, yeah, we should be out of here certainly within an hour.
Let me ask you this, so once he's done, so tomorrow, what is your plan for tomorrow?
My hope.
Yeah.
My hope is that we'll get agreement on an affidavit that would obviate the other witness that we have. You've obviated the need for Bennett. We might again press the issue with respect to the supervisor. And then it's some offer of documents and then it's closed.
Okay, so,
I'm not anticipating calling other witnesses. I'm hoping that we won't have to.
and I take it you have no other witnesses?
No, you're
And I take it, Ms. Moran, you don't have, I should ask, I apologize, Ms. Truitt. You don't have any witnesses, right? Okay, so, so why don't we just wait a moment and wait for Mr. Cole to come back with that information.
Shall we
Would you
take,
like to use my computer to be able to ask you questions?
I have specific articles that I'm pulling up, so.
Are you going to be relying on, you mentioned 2 Globe articles. Are there other Globe articles?
Globe, Worcester Telegram, Herald.
Okay, can we kind of give them the information? Oh, they're gonna get the information, right? So.
Can we take a break?
Do you
It'll
want,
take me 5 minutes to go upstairs and grab the documents and we can continue.
okay, want to take a 5-minute break?
It's also awfully warm in here.
Is it? Well, okay, if you want to take off your suit jacket, feel free to.
Thank you. Thank you for your patience. I appreciate it.
Sure.
I have also, I don't know if Mr. Bourgeois is back yet.
I don't know. Ms. Bourgeois? Why don't you just wait a minute, okay?
It's 5 o'clock somewhere.
Well, what time
It's
is
2
it there?
it's 2 o'clock where he is.
is that a military observation?
Can I point out for you?
Okay,
Okay, Ms. Bourgeois is back. Thank you for bringing that to my attention. Okay, Ms. Pro, what do you have to say?
And Mr. Bourgeois, I have emailed these articles to you.
I'm not sure you even heard. Ms. Bourgeois, did you hear that? Yeah, you're on mute. You're on mute.
Okay. I haven't. Hello?
Yes. Okay, so you have Ms. Pruitt indicated she just emailed you to the documents, okay?
I have let's see, 7 attachments here, yes.
Okay,
Okay,
thank you.
great. Mr. Jean, could you please pull up the November 2017 Globe article? State trooper was ordered to alter the arrest report of a judge's daughter, and now he's suing.
Judge,
Yeah.
if she's going to use them, I'd like to see them now rather than piecemeal. He said he got 7 attachments.
Right.
It was my understanding he got 1 article you're gonna refer to. Now we got 7. Still don't have the actual article.
Well, I know, but you know, she was gonna make copies and then you withdraw
That's what I'm
the,
waiting
We
for.
don't have them.
I know, but she was gonna make, I thought I think there's a misunderstanding here. I thought when you withdrew your objection, the copies that were being made would stop being made. And then because, you know, you withdrew your objection and you said you had it here.
That doesn't, we still wanna see what it is we're talking about.
Okay, so did you send the documents to him too?
Oh, I thought he said that he could pull them up on the internet. I'm pretty sure that was the conversation that we had, and you asked him if he could share the articles with,
I'm sure we're all gonna cluster around my ridiculous.
Well, look, you know, it's,
She said,
Can you just forward us the email?
why don't you just can you forward the email to?
Can
no,
Roy,
Mr.
Mr.
Attorney
Bourgeois
Bourgeois
send it?
has it.
Yeah. Mr.
Attorney Bourgeois has it, he can record it, right?
Mr. Kantrowitz, can I make a point which is in the nature of an objection? I think the undisputed testimony in this case is that the publicity occurred because of a confluence of 3 factors. First, the arrest report had in it graphic sexual imagery. There's no other way to talk about that statement that was in it. Secondly, it involved the judge's daughter. You'll remember Mr. Travers referred to that as gasoline on the fire. The third component is that there's some allegation of cover-up or issues associated with the report revision. It's artificial and it's argumentative to say that if you eliminated any one of those reports, there would be less publicity. I also point out that petitioner is now undercutting their own theory of substantial value. They pleaded in the orders to show cause that the respondents were motivated to avoid the embarrassment, publicity, and cost to rehabilitate. Now, apparently, they've gone over to the other side and saying there was never a real chance of that at all. I don't think this advances the issues in front of the commission one bit compared to the time, confusion, and argumentative nature of it. I object.
I appreciate that. All I'm asking you to do, can you forward what was sent to you, those 7 articles to the parties here? You know, they want to draw it up and whatever.
All right, so I'm being asked to forward the email I just got to my co-counsel. Is that correct?
Right.
All right, give me a minute.
As I said, you know, I want to make it perfectly clear. I asked the parties whether you want to complete this today. I would like to, you would like to, so, you know, I realize it's late, we want to leave, but the parties want to stay, it's fine with me. So although it's inconvenient for some people, so I'm going to allow you to ask certain questions. You're free to object to those questions and let's, you know, get through this.
All right, I've just forwarded the email that I got with 7 attachments to my co-respondent counsel.
Okay, so you should be getting that. Have you gotten that, Ms. Fiore?
No.
And I take it you're speaking for Mr. Kiley in
Yes,
this
I'm
case.
speaking to Mr. Kiley. I'm on his email.
neither.
Ms. Rusconi, have you gotten it yet?
I have not, but I've also been having internet troubles all day.
Yeah, can we just continue with whatever she has right now, so we can just keep this?
Excuse me?
Can we can she continue with the
Yeah.
first one?
Yeah, why don't you just start asking the questions and we'll take it from there.
Mr. Shaw, could you please pull of the November 7th, 2017 Globe article. A state trooper was ordered to alter the arrest report of a judge's daughter. Now he's suing. District Attorney Early, would you agree that this headline relates to the actions of the state police and not what the judge's daughter said or did?
Objection.
Well, he can't answer that without reading the article.
I said the headline respectfully.
Sorry.
Your Honor,
Objection under the doctrine of completeness. It's not fair to ask about the headline only.
Okay, well, we'll get to that in a second. And Mr. Rusconi?
in the interest of streamlining what I don't want to speak for Attorney Pruitt. I don't think there's a debate that there are articles that do not specifically relate to the crash and the OUI of the judge's daughter per se, but rather the events afterwards. I don't think that there is a debate about that.
Okay.
But if we're gonna walk through every article to suggest that there is a debate, I'm wondering if this is a productive use of time.
All of these articles, Judge, most respectfully, are gonna be on or about November 7th, 2017.
Okay.
Okay? And all of those articles, that I believe, if you recall your notes, that's the time period when the complaint was filed in federal district court.
Right.
Before Judge.
Okay.
So that's the generational focus, if you will, from the impetus for the publicity.
Okay.
So,
Your Honor,
Wait, hold on, Mr. Bourgeois.
hang on, Roy. Man, again, you're not talking about the context of what the issue is between October 16th and October 20th.
I realize that. So to short circuit this, given what everybody has said, could you stipulate that this could be an exhibit and then we can leave it at that?
Sure.
Fully realizing what I fully realize your objection, your objection.
Yes.
I fully realize what the objection is.
Yes, on Mr. Early's behalf.
Okay, Ms. Bourgeois, want to be heard?
yes, I do. I'd like to read, if I can, into the record, the very first paragraph of what has now been displayed on the screen is only the headline.
Okay.
If I may, it reads, AB, the woman we've been talking about, had just crashed her car on Route I-190 in Worcester on the evening of October 16. She reeked of alcohol and had what State Trooper Ryan Screevor described as a, quote, heroin kit, end quote, including a dozen needles and a spoon. She admitted performing sex acts on men to support her heroin addiction, according to Screevor's official report, and there's a hyperlink to the report at that point in the article, and offered him sex as well in return for leniency. She then started ranting that her father was a judge. He's going to kill me, screamed Bebo, the trooper reported. So the article begins with exactly what we've been talking about. This is not a meaningful cross-examination. It's a classic example of the problem of the doctrine of completeness. This has no place in this case.
Okay, well, I've indicated, I've suggested a solution, which I believe Ms. Rusconi agrees to that.
At this point, Your Honor, yes,
And Mr. Kiley
No objection.
and Mr. Burke.
I don't, Judge.
Are you, okay,
I don't. I withdrew my objection for the purpose of letting her ask questions about the article. But in my view, this re-victimizes Ms. Bebo, the family, and all of this is just putting more information, gratuitous information that has no relevance to this case, into the internet, into the public spectrum, and it's just destructive of what we're all trying to accomplish here.
well,
It adds nothing to the truth.
Well, I sympathize with your observations. The petitioner is offering those, hold on.
sorry.
The petitioner is offering those as an exhibit. And it's fairly clear that I have admitted a lot of exhibits that have questionable relevance, right? And I'm admitting them basically for the benefit of my fellow commissioners who are not here, so they will have an opportunity to look through those exhibits and give what weight, if any, they will. And I submit that this falls into that category. You know, I fully understand your positions. I'm saying just admit this into evidence, and then she's going to rest, and then you can have your redirected recross examination, and then we'll give it whatever weight we want to give it. And I can't fully recognize what your arguments are. So.
But if I may, Mr. Kantrowitz,
Right.
your comments do not reflect the unfairness of petitioner not listing these as documents in connection with your pretrial order, surprising us on the 8th day of the hearing, and not giving us a chance to go out and collect from the smorgasbord of hundreds of articles that show that the other issues were just as important. This was done tactically because they knew we couldn't do anything about it. We should have seen these documents a month ago.
I agree, you should have seen them a month ago, and what I suggested.
So I ask you to enforce your order and exclude them. You have the right to do that.
What I suggested a half an hour ago, that if we want to rest for today, adjourn for today, you'll get all these documents. You'll have whatever time you'll need to review the documents, and then I would hear you tomorrow. Everybody, however, wants to continue on. So in deference to you all wanting to continue on, we're continuing on. I gave you the opportunity to have a look at these documents before they're offered into evidence, and you're saying you don't want it. So I'm asking you again, do you want me to suspend right now? You'll get all these documents, and then we'll address it again tomorrow morning.
The answer to your question is no, sir. There are limits to what I can do in 10 hours. What I want you to do is enforce your order.
Okay, I realize what you're saying. I've made my decision. I'll note your objection. And okay, so she's offering it. Mr. Bourgeois objects to the introduction of these Globe articles, and I share your frustration. They should have been turned over. You know, like, why weren't they? You know, why didn't you turn these documents over, you know, like last week, 2 weeks ago, a month ago?
Yeah, not entirely clear that we have to turn over documents that we're using in cross-examination. It's not something I think we need to do. And that's what we're, and these are
In the spirit of discovery, you should have turned it over. I think that's abundantly clear, frankly. You knew you were going to use it. You knew it's real evidence. You knew they didn't have it. So, you know, that's problematic, frankly. So, but I'm allowing you to introduce it, okay? So just for the record, Mr. Bourgeois objects. I believe Mr. Burke objects. Mr. Kiley doesn't object, and Mr. Rusconi doesn't object.
I object.
You now object. Okay, and once again, I will make the offer. Do you want me to suspend this so you have an adequate opportunity to review these documents, and we'll come back tomorrow? Okay, if you don't want to do it, then you're leaving me with not a lot of wiggle room here. So, okay, why don't you give those documents to,
So I'm putting in 6, not 7. Do you want me to identify them on the record?
sure.
Okay, so the first one is November 9, 2017. Globe article, Baker investigating why trooper was ordered to change police report. And they'll all be one exhibit? Correct?
Yeah.
Okay. A second one, November 7, 2017, Globe article, state trooper was ordered to alter the arrest report of a judge's daughter, now he's suing. Next article, Worcester Telegram and Gazette dated November 10th, 2017. DA backs impounding of report on judge's daughter. Next article, November 10th, 2017, Globe, head of state police retires amid questions about altered arrest report. November 16th, 2017, Boston Herald, Steve Lynch ordering trooper to alter police report is unconscionable. see, Boston Herald, November 21st, 2017, Charlie Baker confirms link between troopers, DA and scrubbed report case, and that's it.
Okay, that'll be one exhibit, A, B, C, D, E, F, whatever.
Get it.
Okay,
I'll click them for you, so, show me to click them for you.
excuse me.
What exhibit number is this, please?
It would be 56, A, B, C, D, however, and it
And in fairness to the parties, and specifically what Mr. Bourgeois indicated, if you want to come in tomorrow and say, please see the following articles, which we don't have, but they're online from October 17th, 18th, 19th, and 20th, and 21st, then come in and just give us the site for that, and I'll allow you to admit that.
Won't be any. There were no articles until the impoundment order was leaked improperly.
Okay.
I have no further questions.
Okay, thank you very
District Attorney
much.
Burrow. Thank you, sir.
Okay, thank you. Mr. Kiley?
I just want to say, Judge.
Yeah.
This is reprehensible. You've been sold a bill of goods here. I tell you that this is something that they want to ask questions about of Joe Early. Yeah, so we wrangle here for 25 minutes about whether or not it's going to be introduced. You do your best efforts to try to have the information brought in for whatever purpose, all right, whether I agree with it or not, let it come in. They ask one question. They then rest or stop with the questions of Joe Early. Sit down, introduce this stuff, which is so clearly prejudicial. And again, as I said, victimizes this family in the effort to prove what?
Okay, I appreciate your observations. Thank you. Mr. Kiley?
Cross-examination, Ms. Pruitt asked you about your relationship with Judge Bebo and whether you traveled in the same circles. Call that?
I do,
And you responded back in the 90s, correct?
yes.
What was your relationship with Judge Bebo in October of 2017?
In public, it was friendly, polite, courteous. The relationship was very strained. It was a poor relationship.
Why was it strained?
When I got elected, I heard from a friend one day that Judge Bebo was he wasn't Judge Bebo then, he was working for me. He was criticizing me nonstop, if anybody would listen, complaining that, one, if he had been given more time, he would have run for district attorney himself. Two, I didn't know what I was doing. Three, that people I brought in were making changes, that he was constantly criticizing my running of the office, which followed with a phone call from me to him saying, Timmy, I heard that you're killing me. To anybody who will listen, is that true? And he said, yes, you got to understand where I'm coming from. I've been here so long, and you pick Eddie Kakasinas over me to become the first assistant. I said, look, I understand your position, your opinion, but understand this. If you don't stop and it doesn't stop now, you're gone. So make up your mind pretty quickly. It either stops or you're gone.
You were asked in particular about whether you had done anything when you made the observations with respect to the judge's daughter and her physical condition, correct?
Yes.
Are you aware of the content of the strike that? Who was the supervisor who was offering observations at that time?
Margaret Ruwamba.
Is Margaret Ruwamba on your proposed witness list?
Yes, she is.
Was Margaret Ruwamba's testimony the subject of the motion that was sought to be admitted under seal?
Yes, Margaret's affidavit that we asked to be submitted under seal in camera out of the public view.
And again, that has not been allowed, correct?
That's my understanding, although they've been letting a lot in.
I'm not inviting it. Answer the question, please.
All right. It hasn't been allowed in, no. I'm
It
sorry.
was shared with the commission, correct?
Correct,
The commission objected, correct?
correct.
Before Dan Bennett was first assistant, after Dan Bennett was first assistant, Jeff Travers was first assistant, correct?
That's correct.
Senior first assistant.
Yes,
Did Dan Bennett have responsibilities concerning personnel like those that Jeff Travers spoke to the other day?
yes,
Did it include dealing with personnel matters?
yes.
Do you know whether there was a discussion between Dan Bennett and Ms. Bebo with respect to the conditions?
Objection.
So,
Yes, it was Dan Bennett, Margaret Rwamba, and the young woman.
And what were their offers of help to the young lady?
Absolutely.
Were they discussed with you in advance?
I had given a directive, please show empathy and compassion. Please see if we can get her to get treatment. We'll keep her on the office. We'll give her whatever sick time she needs. Please see if she will accept treatment.
But the exact discussion is not something that you directed, correct?
No, he took it further. He said, Joe, let me handle this, and then I let him handle it. I made it clear what I wanted to see happen.
Was there, strike that, did you then have a one-on-one personal conversation with Judge Bebo about the handling of that matter? And again, personal one-on-one,
Yes.
tell me about it.
Well, he's walking down one part of the hallway outside my office. I'm walking up the other. He was clearly agitated, saying they asked her if she wanted treatment. She said she's not using. Dad, I can't get into treatment if I'm not using. They're picking on me. And he made it was delivered to me, and I really didn't have too much to say to him as he walked by me, and he was walking at a good clip.
Did that further strain the relationship?
It sure did.
So when you testified about your relationship, was that a factor?
Yeah, yes.
I have one more. Did you ever have a 3-minute conversation with me?
I don't know. I don't think we've ever had.
Was the advice that you received with respect to this matter confined to a 3-minute or a 4-minute call?
It was went longer than that.
okay, thank you. Yeah, Mr. Scott.
Thank you. I just want to clarify too, when I flip-flopped to my objection, it was because I was able to actually, in the interim while this was going on, read 2 paragraphs into one of the articles which displayed a blatant falsehood and is in contrary to everything we've heard up until this point. That was the reason for my going back. I just, like any reasonable person, I see new information, I reserve the right to change my mind. So that's about.
Okay.
Sorry, DA Earl. We've been talking a little bit about publicity, and this won't take too long, but a defendant can't waive their right to pretrial publicity, or I should say, their right to be protected from pretrial publicity, right?
Right.
So we've heard that, that Judge Dolly said he looked at the case and said he didn't think there was going to be a trial. And that was in his experience as both a prosecutor and a judge, right?
Evidence was overwhelming.
Correct. Now, in your experience, both as a defense attorney and as a prosecutor, you're aware that different judges will make different decisions on the same case on a plea, right?
Yes.
So, for example, there might be a judge that sees an OUI where there's a crash and the same evidence, and a plea is tendered. And when a plea is tendered, the DA can agree to it with the defense attorney, or they can do disparate. So defense can ask for one thing. In this case, the minimum for a DUI is the alcohol education program, 45-day loss of license, 1-year probation, continuance without a finding. Is that accurate?
9024D, yes, it's what we do every day.
And the prosecutor can either agree to that or ask for something more severe.
Correct.
Now, there are some counties, to your knowledge, that will agree to a continuance without a finding, isn't that accurate?
Yes,
And there are some counties that generally speaking do not agree to a continuance without a finding.
absolutely.
And also, in your experience, a judge could see this and say, you know what, I'll adopt the defendant's recommendation. Or you know what, we're not gonna do a continuance without a finding, we'll do probation, but it's gonna be a guilty. But no jail time or anything, that's something that could happen, right?
Correct.
But there's also situations where a judge could see a crash and think, you know what? This really offends me. I'll offer you 60 days in the House of Correction. You can take it or leave it or go to trial. That happens, doesn't it?
Yes, it does.
And at that point, as a defense attorney, you'd agree with me, it's very difficult to walk your clients into jail, isn't it?
Oh, God, yes.
So at that point, faced with jail, more often than not, as a defense attorney, in your experience, you say, you know what? Fine, we'll go to trial, right?
Right,
And that's not, for a case that you plan to not go to trial, right?
yes.
And so when we say pretrial publicity, that never goes away, does it?
Never,
So
especially with the internet.
even if somebody plans on pleading a case, and their case, quite frankly, stinks, they still have the right to be protected from pretrial publicity because they still might have to go to trial, right?
One of our most fundamental rights.
Thank you, I have nothing else.
Thank you. Nothing. Okay, Ms. Burke, nothing. Mr. Bourgeois?
Just a couple of questions, Mr. Early. You testified, I think, on direct examination that long before the newspapers picked up the story, the courthouse was, was talking about this arrest and about this report. Is that correct?
Yes, Judge Despotopoulos told me that.
And isn't it true? And isn't it true that you had concerns about the possibility of unfair, prejudicial pretrial publicity long before the publicity that you're worried about actually happened?
Second I saw the report.
The last area I want to ask you is you have not had a chance to read any of the 7 articles that Ms. Pruitt has put into evidence, have you?
You know, I'm not sure exactly what came in. I don't have a memory of reading any of the articles. Maybe I did, maybe I didn't, but I don't believe I don't know.
Well, I can tell you, because I just read a couple of them myself, that many of them contain direct and extensive quotes from an individual named Dana Pullman. You're familiar with him, aren't you?
Yes, I am.
And he's an individual who had, at the time of these events, a leadership role with the SPAM organization. Isn't that correct?
Yes, it is.
And to the extent that he's quoted in these articles, it may be relevant to people who read them now to know that he no longer has a leadership position with SPAM, does he?
No, he does not.
And one of the reasons he doesn't have a leadership position with SPAM is that he's currently under federal indictment for racketeering and fraud charges in connection with his role with SPAM. Isn't that correct?
I know he's under federal indictment. I don't know what, I know there's an honest services fraud charge. I don't know the extent of it. I do know that he's under federal indictment, yes.
Thank you. That's all I have.
Okay, thank you. You have
Nothing.
nothing.
Oh, we have nothing on redoer.
Okay, nothing. Okay, well,
Then we don't have any reread costs, do we?
we usually don't. So everybody have a lovely evening. Thank you for your testimony. Thank you all very much for your patience. It's been a long day. See you tomorrow morning. Hopefully our final day.
Thank you, Judge.
Thank you.